Lordship, I beg to mention item 9, Lordship.
9.
Yes, Lordship. Kindly adjourn this matter, Lordship. I have some personal difficulty, Lordship, and let it be listed on Friday, Lordship.
Friday, no.
Then Monday, Lordship.
Monday. On the prayer of Mr.
Yeah, Ali, Lordship.
A. Ali, the learned counsel appearing for the petitioner. This let the matter be listed on Monday will be 17th.
17th.
Let the matter be listed on 17th. You have who is on the other side? Have you
Lordship,
intimated?
some Yes Islam name has been shown. He was absent in last occasion, Lordship. Therefore, I could not know him.
Okay. Okay.
Obligement.
May I please, Lord?
Hmm.
I beg to mention item number 31. Lordship, they are going to engage another set of advocates, so we have returned up files of short date may be given.
31.
Yes, Lord. Yes, Lord.
31. You are P. Hazarika.
On behalf of PROCEEDINGS.
What is your name?
SS Bora.
It is Bora. So you'll be appearing or no? You are just mentioning. You are just mentioning on behalf of.
On behalf of PROCEEDINGS.
Mr. So and so, Mr. Bora, just take
It is
his
Bora.
name. It is Bora. Appearing on behalf of P. Hazarika, the learned counsel representing the accused applicant, submits that Mr. P. Hazarika and his team is not going to appear in the matter anymore, and client is going to and the accused applicant is going to engage a new set of lawyers. He prays for some time and let the matter be listed on when CD is received. Let the matter be listed on AB. Okay. On 14th of August. You just intimate them. 14th of August.
I'll do it. Item number 25 and 26.
25 and 26. Did you not receive? Okay, Mr. M.I. Hussain, the learned counsel, appearing for the accused applicant, prays for adjournment of the matter, citing the reason that CD is yet to be received. Let both the matters be listed. Let the matter be listed on
24.
Okay, 24.
Interim is there in both cases.
Okay, interim orders. If interim orders so passed, shall continue till the next date of listing.
May I please, Lordship? I beg to mention item number 17, Lordship. 17.
17, yes.
Lordship, CD is not there. I am on interim, Lordship.
Search sheet has been submitted. So when the matter comes, we'll pass an order.
Right.
I beg to mention item number 27, Lordship.
Hmm.
CD is not received. Lordship, I am on interim.
Okay. 27, you read your Mr. A. Huda is present for the accused applicant. And the CD is yet to be received. Let the matter be listed on 25th.
Interim is there.
25th? Okay, 24, 25, 26. Interim order so passed earlier, so I'll continue until the next day of listing. Or we can put it on 20th. AB, eh? 20, 20th.
May I please, your Lordship? Lordship, I beg to mention item number 34 and 35.
34 and 35.
35, yes, Lordship. Lordship, kindly matter may be adjourned for a week.
34 and 35.
Yes, Lord.
Why? What happened? The bail hearings. Why are you adjourning bail hearings? Why? What happened?
My senior counsel
Who is your senior counsel?
is HR Sodori, Lordship.
What happened to him? He's not in the court. He's in the court.
Yes, Lordship.
CD has come. Okay, send. No, one is AB, one is criminal petition. Okay, on the prayer of learned counsel appearing for the accused applicant, let the matter be listed after a week. 34 and 35. Good. 35 will be petition, counsel for petition. Okay. 18. Yes. Boy.
Second, here's what you judgment what you
Which judgment?
Regarding 36 cases be referred to the division bench.
Okay, that one, okay. When is going to be delivered? Here please tomorrow. Tomorrow, okay, on the prayer of the learned counsel appearing for the customs department. Customs department, let the matter be listed in the next week. Next week, which is not objected by the learned counsel appearing for the petitioner. Appearing for the accusation.
This week,
Huh?
because I have another ground also.
Okay, that is fine. I mean, we'll fix it in the next week. Next week.
Date. Date.
Next week you give a date, okay. Next week on 18th?
18.
18th.
Item 1, question.
Notification में पैसे ले notification सब कुछ टिकट तो खाना पड़ा नहीं और एक किस तो नहीं यही नहीं सोने की ना अपने देने चाहिए एक माउंट ऑफ मोटेशन किस तरह
May it please, Your Lordship. Well, if the person is behind the bar for 60 days for an offence under 316(5), my lord, criminal breach of trust, my lord. Your Lordship will find,
where is the order, where is the earlier rejection order?
my lord, that is, no, that the earlier is not here, not this case, my lord. That is another case arising of the same FIR, my lord. Arising out of same FIR, my lord. I do not have any idea. I have not approached this honorable court. But this has been rejected by Honorable Justice Mitali Thakur.
Kamal Saikia's AB application was disposed of.
My lord,
Kamal Saikia's AB application 576 of 2026 was disposed
yes,
of.
my lord, that was rejected, my lord.
So that order has to be here. No? That all these things has to be disclosed by you.
Definitely, my lord.
Then where is it?
My lord, honestly, my lord, I do not have get any instruction.
Then you have to call your client. We'll put him behind the bus.
No, he is
He
behind
should
the bar.
But put him behind the bus means like we'll extend his stay there.
My lord,
The thing is that all these things has to be disclosed. Today, I mean, there's Supreme Court guideline has come. So
Definitely.
all antecedents, all bail applications rejected, all bail orders, all these things has to be disclosed. There is no disclosure at all.
my lord, definitely. my
So
lord.
you'll have to withdraw this and like file a new petition. There is no other, or else you can do one thing. You can file an additional affidavit,
Oh, yes, my lord.
bringing in all the earlier order, as well as making a statement that.
My lord, I'll file an additional affidavit. My lord,
You file-
honestly, my lord, I don't have any
No,
instruction.
no
Had I been
problem.
an instruction, definitely I'll not file.
No,
this.
because this is mandatory now. I mean,
Yes, I know. Whatever the-
there is not a single statement also that your bail was rejected.
Yes, my lord. Why?
I mean, why not that? At least the
No.
bail was rejected. That statement should be there.
I-
There is not a statement. Forget about the order. There is not a statement also.
No, what my client, what my instruction is this.
Yeah.
My lord, is it,
No, I don't want to say anything,
No,
but
no.
the thing is that I don't know how registry has passed this.
no,
I
there
mean,
is an application on the basis. We have filed an application.
See,
All
see.
Sankhya has not approached me, lord.
AB application has been disposed of. I think it is dismissed, right?
But
So there is no statement that you have come to this court earlier and your petition was dismissed. There is no statement. There is no order.
My lord, what my instruction not Kamal Saikia, there is another one, my lord. There's a Noyan Duty, my lord. What my
Kamal Saikia versus State of Assam, AB 576.
57,
576 2026.
576.
Yes. Kamal Saikia versus State of Assam. Then, and if he is not instructed him, just to tell him that like, I mean, this is not the way to come to the court.
Because he
I mean,
the,
he cannot,
lawyer-
he
my lord,
cannot mislead the court or suppress the facts.
the lawyers have sent me, my lord. The lawyers, my lord. He is behind the bars, my lord.
I don't know now. You'll have to, I mean, you,
No, I'll
you
file
take some time.
No, I'll
you-
file an additional
you
affidavit.
file an additional affidavit, bring all these things on.
My lord, my lord.
Because otherwise, I mean.
Yes.
court
No,
cannot-
I know. I beg apology, my lord.
No, you
I
take.
beg apology, my lord.
Okay,
So that
okay, how much time you want?
within about,
Only an additional affidavit?
oh, yes, my lord.
Just bring that earlier
Definitely.
order on record, and if any other things, I mean, whatever, lower court, The session court, if any order is
Of
there,
course, session court order has been. I have
there,
attached.
I've seen
But
that.
so far, my lord, this is concerned, honestly, my lord, I don't know. Just now I came to know, only my instruction was this, the lawyer has said that others has applied, that is the rejected. my lord.
No,
That's
no, that's what I'm saying, no, that because AB application is there, he has already filed
My-
AB application, that was rejected. So you tell, I mean, when do we want it to be listed? Day
Next
after
week,
tomorrow?
day after tomorrow, or day after, I have some
Okay,
personal difficulty.
when do you
my lord.
want? Next week?
Next,
So you have the other things also to be done.
that-
So when do you want? You tell me.
next Tuesday, my lord, your lordship will fix the next Tuesday.
Next Tuesday? Okay.
But-
Okay, on the prayer of the learned counsel, on the prayer of Mr. P. Bora, the learned senior counsel, appearing for the accused applicant, let the matter be listed on 18th. On
My lord,
18th.
I'm obliged.
Yes.
This is the second bail application, Lordship. Earlier
Mm.
bail application was rejected by your Lordship, that is, you find your Lordship at page 33. Page
Yes,
33,
huh?
the earlier order,
Page 33.
my lord. And that earlier bail application was rejected basically on the ground that charge sheet is yet to be framed. Although charge sheet is submitted, the
Mm.
charge was not raised. That was on that ground, basically your Lordship has rejected my bail application. And subsequently, Lordship, they are the prime witness, Lordship. They kidnapped the victim. And allegation against the present petitioner was that he was detained in the house of the present petitioner. And those two prime witness, Lordship, has been granted bail by this honorable court, coordinate bench of this honorable court, Lordship, page 45.
Please?
45. Out of 5 lordship, all are outside. Only the petitioner lordship is inside lordship. I'm not considering the length of detention and other whose lordship have already been granted bail. The lordship may consider the bail application lordship.
If your lordship allow me, just I want to pray, my lord, that
So he,
in this case, my lord,
so all other guys are there outside, all other persons.
in this case, my lord, in BM 1527, the
Hmm.
TCR will be there in the registry, my lord, in BA 1527. So it may be
BA?
fixed. BA last page 45 is the bail application, my lord.
Huh.
Here, my lord, TCR is called for, and the honorable court, after going for the statement of the witnesses and the search sheet, has granted bail on the 91 days, my lord. So, my lord, along with this BA, my lord, it can be listed.
But that was disposed of.
This was, my lord, there the scan copy will be there, my lord. In some cases, it is done, man. The
In
scan
earlier
copy from that,
cases-
it can be listed, so the
No,
matter will be
but-
expedite the matter, man.
No, the earlier case is already disposed
Dispose
of.
of, dispose of, my lord.
Then,
Then scan copy will be there in the dispose of file, my lord. Sometimes it is done, my lord. Then for expediting the matter, because since the,
But scan copy has already been considered in my earlier bail application, your lordship.
so now because there's some witnesses, statements of witnesses.
This present petitioner lordship is inside lordship. He is on 45, 4 days lordship behind the bar. I have to consider approval.
This has been going on, matter.
there is nothing in this case. He's already been there in the behind the bars.
Behind the bars.
51,
No,
So many days.
no,
All these
that is there.
accused have been released. Investigation must
That
have
is
been
there.
completed by this time.
Yes, the investigation already completed, madam. Charge sheet
Completed.
laid, madam.
Because charge sheet has been
Charge
filed.
sheet laid down, madam.
Charge sheet has been filed.
Right.
So let him go, that he will face the trial.
That's
Heard Mr. A. M. Khan, the learned counsel preparing for the accused applicant. Also heard Mr. M. P. Swami, learned APP for the state. This is an application under section 483 of BNSS KBP3. Praying for granting bail to the accused applicant in connection with PRC number 669/2026 arising out of Kaline PS case number 28/2026 registered under section 140 in the 3/5 of BNS 2023. Please stop. The gist of the facts leading to filing of the instant application is that the informant, wife of Abdul Mannan Bolnia, lodged an FIR alleging that on 4/3/2026 at about 3 p.m. her husband, Abdul Mannan Bolnia, left for Gauhati along with some persons, including the accused applicant, in a Scorpio vehicle. It was alleged that after reaching Gauhati, his mobile phone was found to be switched off, and he could not be contacted. Full stop. In this regard, a missing entry was earlier lodged in Kaline police station. Subsequently, she received a phone call from mobile number 8974916830, wherein the caller demanded a ransom of ₹10 lakhs for releasing her husband. In view of the aforesaid FIR, the police registered Kaline PS case number 28/3026 under the aforesaid sections. Thereafter, after completion of the investigation, charge sheet in the matter was filed. Full stop. The accused applicant in the instant case has referred a bail application. Before the bail application before this court, by bail application number 1892/2026 on 2026, which was rejected by this court on 22/7/2026 after perusal of the TCR. Full stop. Full stop. The learned counsel appealing for the accused applicant submits the accused applicant number submits that all the co-accused involved in the instant case has already been granted bails by different courts of this lower court also, all high court, no? By different bench of different courts, no, by Gauhati High Court, just right, by Gauhati High Court. He submits that accused applicant is behind the bars for last 144 days, and since the investigation is already completed and framing of charges awaited. Framing of charges awaited, the accused applicant should be granted bail, taking into account his long detention behind the bars. Full stop. Full stop. Then you write, Mr. MP Goswami, APP submits that APP opposes the clear of bail of the accused applicant, taking into account the entire facts of the case, and also the fact that all of the co-accused have been released by coordinate bench of this court. This court considered the opinion that the accused applicant should be released immediately on bail. Accordingly, it is directed that the accused applicant shall be released on bail on furnishing of the bail bond of ₹30,000 to the satisfaction of which court?
Learned CGM Kasar.
Satisfaction of lodging CGM Kasar, subject to the condition that the accused applicant shall appear before the trial court as an reply. In terms of the aforesaid directions, the instant bail application is disposed of. That's allowed.
Defendant is in custody since 48 days, Lordship, under the offense section 1031 of PNS, Lordship. Kindly CD may be called first and fix a short date, Lordship, please.
Okay, heard your name?
R. Shah.
Heard by Ms.
Daughter and granddaughter are both murdered. Daughter and granddaughter are both
Heard,
murdered.
heard,
Yes.
Ms. Alsa, learned counsel appearing for the accused applicant. Also heard Mr. MP Keshwami, the learned APP for this case. This is an application under section 483 of BNSS 2023, praying for grant of bail to the accused
Nandini.
applicant in connection with Disney PS case
50.
number 80/2026 under section 103 bracket 1 of BNS. Full stop. Then you write. Okay, we'll not copy anything. Call for the CD, call for the CD, let the matter be fixed on
And 24th, my lord, Monday.
24th of August.
Please, Your Lordship. This is regular bail application, Lordship. And the action is concerned, Lordship, 87, Lordship. Apparently, Lordship, FIR is, Lordship, we find case number 11, Lordship. There is nothing, any section is like again, present petition, case number 11. May I read, Lordship, very short FIR.
Objection
The missing intimation has been given to the outpost, Lordship, and subsequently victim is recovered, Lordship. Will come in that, Lordship. And Lordship, and victim is, Lordship, 21 years, Lordship. No, sorry, Lordship. So,
Make him minor.
We'll see what is there in the CD.
and Lordship.
Heard, Mr.
Lordship, I'm sorry, Lordship. and for a
No, what do you
moment-
want? You want the bail today only?
No, Lordship.
Without CD, then what you are saying? I'm saying that like we'll call for the CD. Then what do you want to submit? You just tell me.
Lordship, just for a moment, Lordship.
No, what are you going to submit?
Lordship, on bail-
I'm saying that we are going to call for the CD. I've seen your FIR. I've seen your FIR. And I'm saying that I'm of the opinion that CD will be required in this matter. What do you want to submit more?
And Lordship, the part of the
No, what do you want to submit more? What part of what?
the victim, Lordship, and the already been by the learned court below, Lordship,
Huh?
and some portion is recorded, Lordship. Kindly for a moment, Lordship. I'm not.
No, what do you want to?
seeking
No,
bail today
I
itself,
don't want to see that. I'm saying that CD will be required in this matter. I have considered your FIR. I've seen it.
Lordship.
They don't keep on insisting on the things because CD will be required. I don't want to give you bail without going through the CD. That's my opinion. You want to enforce? You want to force on upon me?
Lordship, but
Then-
Lordship.
Then why are you arguing? I'm saying don't stop. I mean, CD will be required in this matter. I'm saying that I'm calling for the CD. After consideration of the CD, if you have married, you'll get a bail. Be patient. Heard, Mr. What is your name?
F of law.
F. Hawk, learned counsel appearing for the accused applicant. Also heard Mr. MP Goswami, the learned APP for the state, as well as Mr.
A Sharma. A Sharma.
A.
for the
Sharma for,
Informant. Lordship.
for the informant.
Lordship.
For the informant, that this is an application under section 483 of BNSS praying for granting of bail to the accused applicant in connection with Soigaon Police Station, case number 121/2026 under section 87 of BNS. All for the CD. Let the matter be fixed on 25th.
21. Lordship,
25th of August.
25th.
25th of August. Yes.
This is a subsequent case, Lordship. I was arrested in subsequent case, Lordship. I was arrested in connection with PNA. I was arrested on 14/5/2026.
You were in custody, okay. What is the FIR?
Page
What is Lordship?
25. Your Lordship.
10, Lordship.
Yes.
May I please read? May I read, Lordship?
We'll call for the CD. Heard, Mr.
It is succeeded, Lordship.
Huh?
Succeeded. So, my lord, TCR may be called for.
Okay.
Call for.
Okay. Heard, Mr. SI Bora.
Yes, Mr.
SI Bora, the learned counsel appealing for the accused applicant, also heard Mr. MP Krishnamil and APB Forestry. There is an application under section 483 of BNSS 2023 granting for bail, praying for grant of bail to the accused applicant in connection with Sessions case number 234/2022 corresponding to Boko PS case number 1245/2019 under section 366 IPC. Full stop. A registry to call for the TCR in the TCR of Sessions case number 234/2022 pending which court?
Kamrup Amin Kaur.
Huh?
Kamrup Amin Kaur.
From the court of the session judge.
Passengers.
Session judge.
Kamrup Amin Kaur.
Kamrup Amin Kaur. Let the matter be listed. Let the matter be listed on
26.
26th of
Yes.
26th.
I
August.
got
August. Lordship, I have custody, Lordship, 14, Kamrup just, kindly given the short
Custody
date.
for how many days?
Today is 87 days.
Hmm?
87 days.
87 days.
Yes.
Okay, I
Is
mean,
possible to get for that, Lordship?
short date, what's short date? Okay, we can put it on 24th, 24th,
24.
20.
April, Lordship.
May I please to Lordship? Lordship, matter may be passed for the timing.
Why?
The English council, Aramin is colleagues in another photo. It's going.
Pass away.
None appears.
No one appeared for the petitioner when the matter was called for. Let the matter be listed after 3 weeks. Mr. Bora and Botakur, you all are waiting for 8, 9 something admission matters. But admission matters will be taken up after the bail hearings. So you'll have to wait for some time. We'll just finish it up the bail hearings then sometime we will.
Your Honor,
14.
14.
Wait, please, your lordship. Lordship, the engaged counsel R. Hazarika legs on another.
Petitioner
Hold on.
or respondent.
Hmm?
Non-appeals for the petitioners also.
NJ Doctor, we'll pass it over for 10 days.
My lord.
Nice.
May I please, Lordship? Regular bail application, my lord.
Hmm?
Regular bail application, my lord, submitted matter, my lord.
Hmm?
The petitioner is behind the bar about, my lord, 445 days, man.
Hmm.
Now it is under the evidence stage, it is almost completed and fixed for SD matter.
Hmm?
See the date of arrest matter, he is in judicial custody.
Hmm.
Allegation is, my lord, any affair, it is a victim was
What is the stage? How many witnesses were there?
already 14 witnesses.
14 witnesses.
My lord, I heard that they almost completed. And
Almost
fixed-
completed means how
fixed the
many
matter for
examined?
SD.
How many examined?
My lord,
How many examined?
already 14. There are 14 witnesses, all
All are examined.
all are agreed. And now it is fixed for SD matter.
Fixed for
Yes.
final hearing.
Statement of
Statement
defense.
defense.
Statement of defense.
Statement.
Okay.
Look, I'm for informing, my lord. Already 5 DW has it's for Fada DW.
Hmm?
Fada DW, only 18, my lord.
Further?
DW.
Okay.
On
How many
18.
DWs are there?
DW, already 5 DW has examined one.
Five
Five
DWs
examined.
examined.
Seven. I have, but.
No, I have got,
Letter is
I have got a latest information.
that are
No,
Already
no.
5.
Now, how many PWs were there? 14.
14.
And DWs 5.
5.
And all examined.
the case is fixed on 18 for further events, further details.
For there is DW.
My humble prayer, my lord, petitioner, innocent, my lord, at this stage, he will cooperate with the.
The accused is a habitual offender, my lord. He raped two minor girls, my lord. He raped two minor girls.
FIR is page 9, madam.
At this stage, if he is released on bail, there is the absolute possibility of his absconding, my lord.
No, well, he is the traditions of the prayer, my lord.
Follow what he-
On
Two
the
people, no?
very day, my lord, he was sitting on the bed and off in the TV.
Well, my lord, minor girl 7 and 8 years, my lord.
7 and 8.
Allegation of raping two girls.
Two girls,
In the
two victim,
affair.
my lord.
Huh?
Their statements are there, my lord, as PW1 and PW2, my lord. Their statement, in their statement, categorically stated how he has committed the offense, my lord.
There is every possibility of his absconding, my lord.
And at the stage of my lord, ending my lord stage, my lord, it is the lordship may not consider, my lord, there is a chance of absconding, my lord.
Okay, heard Mr. A along the learned counsel appearing for the accused applicant. Also heard Mr.
Be because.
B Sharma, the learned APP for the state, as
B.
well as Mr.
Be Bikhoya.
B Bikhoya, the learned counsel appearing for respondent number 2. This is an application under section 483 of BNSS 2023 praying for granting bail to the accused applicant in connection with POCSO case number 113/2025 arising out of my own case number 67/2025 under sections 351 in bracket 1/65 bracket 2 of BNS 2023 read with section 6 of the POCSO Act 2012. An FIR was lodged on 25/2025 by one Morzina Begum, alleging that on 4/4/2025, her daughter, namely X, aged 6 years, and her nephew, namely Y, aged 7 years, told her that the accused applicant had undressed both her daughter and nephew, and thereafter committed rape on them. It was alleged that due to threat provided by the accused applicant, there was some delay in lodging the FIR. On receipt of the FIR, police registered my own police station case number 67 under the aforementioned sections. After completion of the investigation, police have submitted the charge sheet and the trial proceeded. And at this stage, 14 PWs have already been examined and some DWs have also been examined. The learned counsel appearing for the accused applicant submits that since most of the witnesses have already been examined and he is behind the bars for last how many days? 440 days, he should be released on bail. The learned APP, on the other hand, opposes the prayer of bail by citing the reason that since the bail is on the since the trial is on the verge of completion, there is no necessity of giving any bail to the accused applicant at this stage. His argument is also being supported, has also been supported by the learned counsel appearing for the respondent number 2, full stop. TCR in the instant case has been received and the same is queried. And on hearing and on considering the submissions made by the learned counsel appearing for the respective parties, and also taking into the fact that the trial is moving on a reasonable pace and the same is expected to be completed soon, this court is not inclined to grant any bail to the accused applicant at this stage. Accordingly, the instant bail application is rejected.
Right. Oh, shit.
May I please, Lordship? Lordship, my senior, Mr. RKD Chaudhary, is not well, Lordship. Kindly adjourn the matter for the day, Lordship.
He is not keeping well.
Yes, your Lordship.
My lord, on
He is
last,
not keeping well for
my lord,
last
on
2
last
days.
session, some other was said that he was entrusted, my lord.
Huh?
On the, kindly see the last order, my lord. And I have served the extra copy also, my lord.
The learned counsel applicant is directed to serve copy of the bail. Mr. Singh was there. Mr. Singh was appearing in this matter.
My lord, in place of him, he was appeared. He has appeared, my lord. And also
Mr. Singh's,
extra copy taken by him.
1 second. Mr. Singh on standing counsel was appearing. But it will be under him, no? Mr.
Yes, sir.
RKD Chaudhary. He is the deputy solicitor general. And he is the uh, main counsel for NCB. He is not keeping well. But
Lordship,
who is Mr. Singh?
I,
There is somebody called Singh, Mr. I Singh,
Indrajit Singh, my lord.
Indranil Singh. He said that he is also a standing counsel.
But Mr. RKD Chaudhary will be in this matter, Lordship.
Okay, we'll give her a date. Your name?
P. Rabha.
P. Rabha.
P. Rabha.
MSP Rabha, the learned counsel, appearing on behalf of Mr. RKD Chaudhary, the learned deputy solicitor general and standing counsel of NCB, submits that Mr. RKD Chaudhary is not keeping well. And therefore, prays for adjournment of the matter. Prays for adjournment of the matter. Mr. A.K. Talukdar, the learned counsel for accused applicant is present. Let the matter be listed. When do you want?
Next week, Lordship.
Let the matter be listed in the next week.
My lord, maybe on 20th date, maybe.
Next week, we have given a date next week.
My lord,
Next week is very, very near.
my lord, other matter is.
Very near.
Other important matter, I may not, my lord.
Okay,
That's why.
next week sometime on
If it is on 20th, my lord, I will not fail, my lord.
20th,
20th.
20th.
17.
17, somebody mentioned it, no? Somebody wanted to mention it, but charge sheet is filed.
17.
Correct? 17,
Yes, sir.
charge sheet has been submitted.
My lord.
And where is that counsel? We'll take it up after some
My
time.
lord, my lord.
19.
CD has come in this.
My lord, scan copy was called for, my lord. It was received.
Huh?
Scan copy called for, it was received, my lord, as per call. Oh, no, my lord.
It was case
I-
diary. It says it's CD in all our orders. Okay, we'll take it up after some time.
My lord.
Yeah, please, your lordship.
Hmm.
Item 20.
CD has come.
My lord, charge sheet submitted, my lord.
Charge sheet submitted is
Mine.
going to appear. Mr. Bora.
Yes, I know.
Heard Mr. B. Bora, the learned counsel, appearing for the accused applicant. Also heard Mr. B. Sharma, the learned APP for the state. This is an application under section 483 of BNSS 2023, praying for granting bail to the accused applicant in connection with Bullockganj Police Station case number 114/26, registered under section 64 in bracket 2. Bracket K stroke 296, bracket 351, bracket 2 BNS. The learned APP appearing for the state submits that charge sheet in the instant case has already been laid before the jurisdictional court. By charge sheet
Charge sheet
number
number 133 of 26, dated 28/6/26.
in view of the aforesaid, the learned counsel appearing for the accused applicant submits that liberty should be given to him to approach the jurisdictional court for appropriate relief, full stop. Taking into account the aforesaid submission, this instant a bail application is disposed of with liberty to the accused applicant to appear to approach the territory, approach the jurisdiction court for appropriate relief.
My lord, here in the petitioner was in interim, my lord. Thereafter, search sheet also submitted, my lord. But in the last, Lordship may kindly present last order, my lord. After interim, he has not appeared before the IO, my lord.
He hasn't appeared.
Not appeared, my lord. Thereafter, last order, my lord, court was granted to appear through VC mode also, my lord. That whether he is appeared or not, that,
Why VC mode was allowed?
my lord, here in the last order, it was respected, my lord. Or if he is, my lord.
Okay, we'll see when the matter comes.
May please your lordship, this is a 482 anticipatory bail application. On the previous occasion, CD was called for. On the previous occasion, CD was called for.
My lord, CD not received, my lord, they are in interim, my lord. In 22, 23, my lord, both, my lord.
Okay, your name?
S. Nisha Sultan.
Huh?
S. Nisha Sultan.
Heard as Nisa Sultan of the Learned Council appearing for the accused applicant. Also from the B. Sharma, the learned deputy for the state. CD not received, later matter be listed when?
My lord, 20, my lord, 20.
Later
20,
be listed on 20th August. Both the orders, both the cases.
Both
same
the
order,
cases, ma'am.
Same orders.
Yes, there is no difference.
Is the reason come?
My lord, item number,
25.
my lord, CD not received, my lord. They are interim, my lord.
Okay, CD, your name?
Armali on behalf of S.
R?
Armali.
R. Malik, the learned counsel is present for the accused applicant. Mr. V. Sharma, the learned APP is also present. CD not received. Interim, let the matter be listed on
26th August.
26.
Ma'am.
Why?
From Thubri, my lord. It is 10, my lord.
26 August.
My lord, then 19, no, then my lord, 21, my lord.
21st.
My lord.
21st August. Interim order so passed earlier, shall continue till the next day. The earlier two matters also interim order was there.
My lord, interim, my lord.
Earlier two matters also interim order.
My lord.
What's the place?
It is from long cover. Interim. 28.
But I am on interim. In last occasion, there was submission from the public prosecutor.
Time being
Charge sheet has been filed. So
Scan TCR has been called for, my lord.
Hmm?
Scan TCR has been called for. It is received, my lord. My lord, I have flag marked the 183 statement of the victim girl. And she has implicated and she became pregnant. And now, my lord, trial notice started, my lord. So, my lord, her evidence is very much necessary, my lord. Because the
DNA
state,
sample was collected, whether it was sent for forensic examination, or if it is missing in the report. I supplied my DNA sample and the
It will take some time.
take some time, my lord. That time, in the last occasion, I prayed, my lord, till my lord, the summon is issued, my lord. The interim order may be extended.
Go to the lower court and appear and seek a bail there.
The problem is that, my lord, I have not received the summons.
Give me this TCR.
but
what else?
my lord, her statement is very much clear, my lord. Her statement and her mother statement. DNA maybe, my lord, will
As
come, my
per
lord.
the FIR, my lord, she is mentally retarded, my lord. Sir, my lord.
Yes, well, she said that I am taking treatment from doctors, my lord, and
And they have lost the FIRs after 7 months, my lord, seeing the condition of the girl. So,
Who is mentally retarded? Manna Salim,
My lord, the victim.
the victim girl.
One of the statement also she said that I am regularly fetching medicine.
Right, please. That's this. 20. 24. 29. 14, please. 5. 24.
Your name?
As Mrs. Madam.
Heard Mr. S. Biswas, the learned counsel, appearing for the accused applicant. Also heard Mr. K.K. Parasar, the learned APP for the state. This is an application under section 482 of BNSS 2023, paying for granting pre-arrest bail to the accused applicant in connection with Tezpur PS case number 180/2025 under section 64 in bracket 2, bracket K of BNS 2023. In bracket, you can write corresponding to GR case number 480/2025. An FIR was lodged before the officer in Sir Salonibari police station on
13/3/25, madam.
on 17/3/2025 by the informant alleged interiorly that her daughter is it about 27 years, is mentally is a mentally ill person, and the accused person is also a resident of their village. It was alleged that taking advantage of the mental condition of the victim lady, the accused applicant had committed rape on her in the nearby jungle many times. Then you write, it was alleged, and it was also stated that her daughter, his daughter is undergoing treatment for mental illness and when mental illness, then you write thereafter on 8/3/2025, when he took his daughter to hospital for medical examination and treatment, it was found that his daughter was carrying a pregnancy of 7 months. When she was asked by the informant, she told him that the accused applicant had raped her several times in the nearby jungle, full stop. On the basis of the FIR, on the basis of the aforesaid FIR, Tezpur Police Station case number 180/2025 is registered under the aforementioned sections. A coordinate bench of this court, white order dated 29/5/2026, has granted interim pre-arrest bail to the accused applicant with a direction to appear before the investigating officer and cooperate with the investigation. Full stop. Okay, anyway, the learned counsel appearing for the accused applicant submits that in terms of the order dated 29/5/2026, the accused applicant has already appeared before the investigating officer, and his statement has been recorded by the investigating officer. He further submits that the accused that the victim lady is a mentally imbalanced person, and therefore the accusations against the accused applicant cannot be relied upon. Full stop. The learned APP on the other hand opposes the prayer of the bail of the accused applicant, anticipatory bail of the accused applicant. Full stop. The CD in the instant case has been produced before this court, and the same has been scan copies of the TCR over. Charge sheet filed when? Huh? When you write after completion of the investigation, charge sheet was filed. You have not mentioned about charge sheet.
No, my lord,
After charge sheet was filed on. No, number is not when. Only date. 11/6/20. Then you write TCR has been received. No? TCR scan copy of the TCR has been received, and the same is perused. Full stop. Then after perusal of the materials available in the TCR, and after hearing the submission of the learned counsel appearing for the respective parties, this court is of the considered opinion that at this stage the accused applicant cannot be granted pre-arrest bail. Accordingly, the order dated 29/5/2026 passed by a coordinate bench of this court, whereby interim protection was granted to the accused applicant, is cancelled. In terms of the aforesaid direction, the instant application is disposed of as rejected.
till I appeared, and till then, my lord, I may be protected from you. Well, because otherwise my trial has begun. Well,
I have given you the option before hearing the matter. You were insisting on the DNA and other things. I have given you the option. You did not agree to
I
that.
just submitted that DNA samples were collected and it was sent
And
for.
I gave you the option, Mrs. Biswas. I gave you the options that you go and appear there. I would have
Sorry,
given you,
I couldn't
I would
understand.
have given you the protection till that time. But you did not agree to that. You were insisting on DNA and
I'm
all.
sorry, I
all
was
that
praying
things.
for that.
There are so much of material against you. How can this court can grant bail? They cannot grant. There are prima facie a lot of materials against you.
Till then, my lord, I will appear.
No,
Till
that's
then-
what I said. In the very beginning, I
Sorry,
asked you.
I was also.
Now it can, nothing can be done. Now nothing can be done. You should have been smart enough to take that option and taken that order, but you were not. Now nothing can be done. Yes, next matter.
Please, your lordship. The report was followed.
What is this? What report? This without complaint and without FIR. Huh?
There is GD entry.
This is the trend. This is the trend we are seeing. I mean, recent trend.
GD entry is there, lordship. GD entry is there.
Then GD entry, on the basis of GD entry, police is not going to arrest you. What is their apprehension?
Lordship,
Whether police can arrest you on the basis of a GD entry?
don't know whether they.
You tell me the law, but it's a settled law, whether police can do it without filing an FIR or issuing a notice.
Notice also has not been issued.
They will dismiss this.
Lordship, I am already on interim, lordship, interim protection.
So we'll dismiss this. There is no case filed against you.
That report may be called, lordship, but since last two occasions the report was called.
One signal we have received. The report cannot be submitted and only DPLP mentioned, no date of occurrence is mentioned in the order. We have sent the signal.
We will take it up. We'll take it up in the second half. You find out if call this person and find out what is there. If there is any FIR filed. But if the GD entry is there, what is the difficulty in finding out that whether an FIR is filed or not? After 2 weeks.
GD to mention as. First image or mention as. Party nomination. Party nomination.
Okay, right. Report as called for by the order dated 8/6/2026 is not received. Let the matter be listed on 14th. On 14th August. 14th.
Interim may be continued.
The interim order so shall continue.
Declare as.
It has been filed, my lord. Summons has been received.
Hmm?
Issued to the petitioner, my lord, to appear on 14th of this month, my lord, August.
Hmm.
To appear there, my lord.
So he's saying that he'll go and appear there.
Yes.
Hmm? Okay, he's saying that he will go and appear there. Let him appear. So you don't want him to go appear there?
Yeah, lawsuit what happened, as per Supreme Court direction, lawsuit, their criminal antecedent has to be disclosed in the affidavit. They have suppressed that matter. By suppressing that thing, they have obtained the anticipated bail application lawsuit. Thereafter, lawsuit, file an additional affidavit lawsuit and the bail's case. Four para filed lawsuit. They are mentioned all these cases lawsuit. Thereafter, they are attending this petition or some.
But anyway, now charge sheet has been filed. Let them go and appear there. But I mean, all these things has to be disclosed, Mr. See.
I was newly engaged in this case, my lord.
But I mean, then the consequences will follow.
Definitely, my
I
lord.
mean, there is
I
specific
will appear
guideline.
there, but if anything is there, but definitely that court will. file
There's a
for-
case called Jeba versus,
My-
and I have it.
Yes, ma'am.
Jeba versus, I forgot this thing. So wherein the guideline has been given by the Supreme Court specially. They all antecedents have been, in the morning also I have told Mr. Bora because he did not disclose about his earlier bail. So all these things has to be disclosed. If you do not disclose it, I mean, the petition will go.
I don't know whether any earlier cases there, my lord.
So you'll have to ask your clients now that like if you do not
Madam.
disclose this,
Madam.
then it will be problem for him.
My lord, I understand.
Every antecedent, every bail
Madam.
that he has filed before any court,
My lord.
that all details have to be given. All details and orders and all. But anyway, this case, let him go to the trial court.
My lord.
Oh, I mean, you're again insisting the charge sheet has been filed. Let him go. What should I cancel it now? No, I don't want to pass that order. I am asking him to go there and appear. I mean, you unnecessarily don't insist on certain things. That will be considered, no?
I've been asked to appear on 14th of August, my lord.
So his statement has been recorded. Now charge sheet has been filed. Let him go and appear there.
Sorry.
Mr. Chaudhary, you go to the trial court and like you save your energy,
Yes.
enthusiasm, wisdom, learning, everything for the trial court. You go there, okay? You go there and oppose there. Third, Mr.
Yes,
M.S. Sheikh,
Mukta.
the learned counsel appearing for the accused applicant. Also heard Mr. P.S. Lockhart, the learned APP for the state, as well as Mr. B. Chaudhary, the learned counsel appearing for respondent number 2. This is an application under section 482 of BNSS. Praying for pre-arrest bail to the accused applicant in connection with Beharli Police Station case number 63/2026 under section 1091 of BNS 2023. Full stop. The coordinate bench of this court provide order dated 19/6/2026 has granted interim pre-arrest bail to the accused applicant. By its order date likha gaya. And in terms of the aforesaid direction, it is submitted by the learned counsel for the accused applicant that the accused applicant has already appeared before the investigating officer and his statements has been recorded. Full stop. The learned APP submits that charge sheet in the instant case has already been filed by charge sheet number.
It says 5/26, dated 25/6/26.
It is also submitted by the learned counsel appearing for the accused applicant that summons.
Yes,
in the
14th of August.
Summons has been issued in the case by the trial court.
Trial court.
And the same has been received by the accused applicant. Accused applicant wherein he is directed to appear on
14th of August, ma'am.
on
Coming Friday.
14th of August, full stop. In view of the aforesaid, the learned counsel appearing for the accused applicant submits that he should be protected till 14th of August so that he can appear on 14th of August, full stop. Taking into account the aforesaid submission, the instant AB application is disposed of with a direction to the accused applicant to appear on 14th of August 2026 before the trial court, and till such time, the interim order was interim anticipatory bail granted to the accused applicant by order dated 19/6/2026 shall stand extended. In terms of the official direction, the instant may be applicable disposed of.
Obliging.
Party two. Wait, is your lordship.
Yes, that he has come.
Lordship, here, what happened, Lordship, FIR Lordship will find on page 13, Lordship. It is earlier rejected by this Lordship. What happened, Lordship? The 3 person who was Lordship stolen that material, Lordship, they have admitted they have stolen that material, Lordship. It was recovered from them, Lordship. They were subsequently released on bail, Lordship.
Hmm.
Now, against this petitioner, that was rejected, Lordship, in the month of June, Lordship. That is on page 23.
Who have been granted bail? Who have been granted
That
bail?
order, Lordship, will find on page
No, how many accused persons were there?
three accused person, Lordship, page 18.
Three accused persons were there, all granted bail.
Yes, Lordship.
Huh. 3 accused persons named in the affair.
They were arrested, my lord.
They were not named.
They
unknown
were
person.
arrested upon the spot.
Yes, Lordship.
Correct. So
Subsequent-
they were granted bail. Then
He
this person is who? Who is this person? Huh?
They were from the place of occurrence. When
Okay.
carrying my lord, the rod, my lord,
Hmm.
he played the well. That three were caught by some local person.
Okay.
But the accused person, Lordship, they have stated they have stolen the material, Lordship.
Where is that?
FR, that is on page 13, Lordship.
No, but that they have stated that. Where did you find it?
The Lordship, can it say second paragraph in the FIR, Lordship? Page 13, Lordship.
1 second.
The bail order also, Lordship, it is reflected
The
on.
JFMC has granted bail. JFMC was under the impression that they were attempting to commit theft.
But Lordship, in the orders, Lordship, it is
It
reflected
is in the order. He says that like attempting to commit
but the
theft.
stolen articles have been
Stolen material was
already recovered.
No, stolen articles have already been recovered, but they were attempting. They did not commit the theft.
Well, in the FIR, Lordship, they said they have confessed, Lordship, in FIR. Page
So
13.
commission of theft and attempting to commit theft are two different things.
But in this.
And he got confused. That's then again he writes stolen goods has been recovered.
But in the FIR, Lordship, they said, Lordship, they have confessed, Lordship. Paragraph 2 of the page 13, Lordship. Second paragraph of the FIR, Lordship. After page 13, Lordship.
After checking the stolen materials, I can verify that it belongs to our site, ex-tech Magabar. The persons got red-handed who also confessed the act of stealing are Kamal Stealing are Kamal Gupta, Idul Hussain, Najim Hussain. So I request you to. So you should go unpunished.
This lordship is a.
You were involved and like three other people, three other persons were, persons had spent 30 days in jail.
Lordship, whether they have implicated me or not.
No, your name was there, they have implicated.
Lordship, since
So
lordship.
better go to the jail for some time, then you come back.
Lordship, since material already been recovered, the person who has
Doesn't
committed the
matter.
offense, lordship, they have admitted, lordship.
Doesn't
Since
matter.
lordship, I am ready to cooperate with the investigation, lordship. I will appear if this charge sheet is submitted against me, lordship. I will appear.
All
lordship,
thieves say so.
That any stringent condition, lordship.
All thieves say so.
Any stringent condition, lordship.
Let him go. Heard Mr. B. Chaudhary, huh? Heard Mr. B. Chaudhary, the learned counsel appearing for the accused applicant. Also heard Mr. B. Sharma, learned APP for the state. This is an application under section 482 of BNSS 2023 for praying for granting bail, pre-arrest bail to the accused applicant in connection with Nunmati Police Station case number 73/2026 in bracket corresponding to GR number 1627/26 under sections 303 in bracket 2/112 bracket 2 of BNS 2023. Full stop. An FIR was lodged on 5/5/2026 by one Swapnil Madhav Das, alleging inter alia that he noticed that since couple of weeks reinforcement bars were found stolen from their store and construction area. It was alleged that yesterday night, that is, it was alleged that on night of 4/5/2026, they found few bundles of rod stolen from their area, and after a while, they received the news that local people caught 3 persons red-handed with the materials and delivered the same before the police. Police arrested three accused persons, namely Kamal Gupta, Idul Hussain, and Nazim Hussain. It was stated that the fourth person managed to flee from the site. Full stop. On the basis of the FIR, police registered Nunmati Police Station case number 73/2026. This court wide the accused applicant had approached this court on an earlier occasion by filing AB application number 1139/2026, which was rejected by this court on 11/6/2026. After perusal of the case, it is the learned counsel appearing for the accused applicant submits that all 3 persons who had been arrested by the police have been granted bail by different courts, granted bail by the different courts. He submits that the accused applicant was in fact not involved in the alleged offense and he has been wrongly implicated. He praised that the accused applicant shall fully cooperate with the investigation and therefore praise for pre-arrest bail to the accused applicant. A CD in the instant case has been received and receipt and the same is perused. Mr. B. Sharma, the APT, opposes the bail application, the prayer of bail of the accused applicant. After taking into account the materials available in the case diary, as well as The fact that the other three co-accused have already been granted bail. This court is of the considered opinion that the accused applicant should be granted PRS bail at this stage. Accordingly, it is directed that in the event of arrest of the accused applicant by the investigating officer in connection with Gauhati PS case number 3073/2026, he shall be released on bail on furnishing of a bail bond of rupees 30,000 with a security of like nature to the satisfaction of the arresting authority, subject to the following conditions. The accused applicant shall appear before the investigating officer within 7 days from today. Number two, accused applicant shall make cooperate with the investigation and shall not and shall make himself available as and when called for. Then accused applicant shall not try to temper and hamper that clause, shall not try to temper or hamper with the investigation, in whatsoever manner. Full stop. Next paragraph. In terms of the aforesaid direction, the instant AV application is disposed of. CD to be submitted.
Highly obliged.
Kindly pass over, my lord, for the time being, my lord. Senior is on lag, my lord. Kindly pass over for the time
Why?
being, my lord. Senior is on lag, my lord. Senior is on lag, my lord.
Like 1906.
May I please, my lord? Okay, in this case, the lordship earlier rejected the prior bail application. My lordship rejected order page 28 and 30, my lordship. So, my lordship, what happened in the present circumstances is that, my lordship, after that, all the co-accused in this case, my lordship, some of them are lordship protected and some of the court number 9 protected, my lordship. And all the items and mobile phone and ATM could already been seized. And
Yesterday also we passed
yes, my
over.
lordship, that is the. And that time your lordship cited that
Mr. Sharma, that same case, yesterday we passed 2 orders. IPL betting.
bill betting and game.
IPL betting, yesterday we allowed those cases. Let them go this case also. Yesterday, which was the order? Give me.
My
the order.
lordship, the bail application, AV 1819.
You have the order.
The lordship is not uploaded, my lordship.
Hmm?
It was not uploaded in the website, my lordship.
When?
E-court I have started in the morning 10.
It is not uploaded.
In the 10 it was not uploaded.
Huh?
In the 10 a.m. I have checked in the e-court, my lordship. At that point in time it was not uploaded, my lordship. Right now maybe my lordship at 10 a.m. my lordship. I will provide it. My
We upload cases every day. I sit in the court till
Right.
9 o'clock.
Lordship, yesterday I checked at the night it was not, my lordship. In the morning also 9 a.m. I have checked it, my lordship.
Please find out. Please find out. If somebody is not uploading the cases every day, then the person will be in
Night was not
difficulty.
there.
I'm telling you. I sit there in the court till 9 o'clock. And and then somebody is not uploading the cases, then it will be a problem. We'll pass an order.
My lord.
Yes.
Deep levels, my lord.
Take down the details and pass an order. Similar order will go. Same order.
40. I'm sorry, my lord, I was not there. Well, this case, my lord, from record, my lord, everything is against me, my lord.
Everything is against you.
Everything, my lord. My
Then
lord,
then
even,
why?
my lord, the FIR could not be read out in the court also, my lord. To be
Ah.
honest, my lord. If your lordship will have a look at page 12, my lord, the FIR, my lord.
Page 12.
Page 12, my lord, the FIR, my lord. It cannot be read out in the court also, my lord.
Okay, let me read it.
My lord.
Yes.
Now, my lord, I have narrated my fact, my lord. If a lordship turns to page 7, my lord, paragraph 8, my lord.
Hmm. Yes.
Now, my lord, the police, well, the investigating agency, my lord,
Hmm.
after investigating the case, my lord, has filed a charge sheet, my lord, that your lordship will find at page 27, my lord. It
Hmm.
starts from page 27, my lord. My lord, while filing the charge sheet, my lord, they have cited, my lord, 13 number of witnesses, and out of which, my lord, 2 witnesses have been examined, my lord. Now, I want to draw your lordship attention to, my lord, page 30 for a once, my lord. Even the investigating officer also, my lord, while filing the charge sheet, my lord, page 30, my lord, all those columns, my lord, below, my lord, 13, serial number 13.
Hmm.
Lordship got it, my lord. If FIR is false, indicate action or proposed to be taken under section 182/211 IPC.
Hmm.
My lord, the police is also not sure about this, my lord, FIR, my lord. Now, 14, my lord, result of the laboratory analysis expert opinion, medical examination, 2 numbers of medical report of victim in which Dr. So-and-so, my lord, opined that no injury seen, my lord. So now, my lord, my submission before your lordship, my lord, out of 13, my lord, 2 witnesses already have been examined, the informant as well as the victim, my lord. And my lord, it is not a believable case, my lord. So recently also, my lord, on my lord, in the month of last part of the month, my lord, July, my lord, the Supreme Court, my lord, same thing, my lord, on a POCSO, man. There also no injury was found.
Who alleged this thing, rape here?
Here, my lord, maternal uncle. That apex court, my lord, maternal uncle.
No, maternal uncle, maternal uncle. This is a case of quashing.
Here, my lord, in the instant case, my lord, my submission is very limited.
This is a case of quashing.
My lord, case of quashing.
The quashing stands in a different footing, Mr.
So, my lord, here in the instant case, my submission is very limited, my lord. The deposition, my learned friend does not need to, my lord, summarize, my lord. Everything goes against me. So, my lord, there are 13 numbers of witnesses. The prime witnesses, the victim, and my informant has been examined, my lord. So, that your lordship will consider my bail, my lord. I have nothing more submission, my lord. And whether it is possible, my lord, that can I rape my child, my lord?
I mean, we are finding so many
That's
cases.
why, my lord. My child, my
Mr.
own
Doc-
child, my lord.
Mr. Doctor,
That's
we are
why, my
finding.
lord, I have not made any more submission, my lord.
I understand it's very difficult
Very
to,
difficult,
very
my lord.
difficult to this thing, but these things are happening. It's
Yes.
not that it's not happening.
But for own child, my lord.
And an allegation by the child itself.
Yes.
It's not by the mother.
Not Sabas. But everything is against me. Everything against me.
Thing is, the
My
allegation is
record, my
by-
lord, everything is against me. But only thing is that, my lord, can I rape my own daughter, my lord? I leave it to your lordship, my lord. Lordship will.
Here, my submission is.
No, I'll just come back in
My-
5 minutes. In 5 minutes, I'll come back. Yes,
Ma'am, my submission, my lord, 13 number of witnesses, and he has been behind the bars for more than 1 year, my lord. He was arrested on 15/9/20, sorry, 5th,
when was the charge sheet filed?
charge sheet was laid, my lord. Yes. Charge sheet was laid, my lord, on 19/10/25, my lord.
19/10/25.
25.
Charge framed? Any idea?
My lord, search frame, my lord, on 22/12.
22/12/2025.
Under section 64.
Okay, no, wait. Then, last witness examined,
On my lord, as per record, my lord, 17/4/2026.
17/4/2026. And already how many? 2 witnesses?
Informant and victim, 2 witnesses. Prime witness, man.
Okay. Yes, what do you have to say?
Why? Lordship and PW2 is the my lord 15 matter.
Hmm.
Lordship may kindly place our position before the court and 183 statement, my lord. In both, she is very much consistent, my lord. And there is serious allegations against her father, my lord. 12 years of age, my lord, child, my lord. How he claim for such type of my lord allegation against his father, my lord. Lordship may kindly place, my lord. And some other materials are material issues are yet to be examined, madam. And one scan copy received only on 12/6, madam. And scan copy received on 12/6, madam. At that time, madam, 2 witnesses were examined.
12/6.
Madam. And when the madam, other witnesses are examined, that is not here, madam. The record. And Lordship, the court below 3 times rejected, madam. After going through the examination of the victim and informed manner, only on the consideration that safety of the victim manner and considering gravity of the nature. My humble submission is that manner may not consider a vegetation by considering the manner.
Okay.
Previous in the but the kindly place of the situation of my how there's no now.
Heard Mr. N.J. Datto, the learned counsel.
Medical report may be also.
My medical is also here. I have take my matter, opinion matter, 20 matter. Opinion 20.
Huh?
Medical report is also there, but I have take my
20 minutes here, please.
opinion man, opinion 20. Opinion partner.
Yes, I have seen.
Opinion man.
Delhi High Court also held my lord, if he is biological father, man, it's not what he need to be taken, can be paid my lord. As he returned to again to a home, my lord, but victim is going to selling.
They are staying separately now.
Now when he is and they were in the bottom, they returned to now Gauhati, my lord, in native place.
Now they are staying in native place.
I'm a serviceman, but I will not tamper no chance of tampering everything.
Heard Mr. N.J. Datto, the learned counsel, appearing for the accused applicant. Also heard Mr. B. Sharma, the learned APP for the state, as well as Mr. R. Hazarika, the learned counsel appearing for the respondent number 2, informant. Full stop. This is an application under section 483 of BNSS 2023, praying for granting bail to the accused applicant in connection with special POCSO case number 132/2025 under section 64 in bracket 2, bracket F stroke 65 bracket 2 stroke 85 of BNS 2023, read with section 6 of the POCSO Act pending before the court of POCSO Act. You just write POCSO Act. Okay. Then you write an FI was lodged by the informant before Pulivor Police Station on 19/8/2025, alleging inter alia that the informant got married to the accused applicant in the year 2011 and their elder daughter is about 13 years, second daughter is about 7 years, and third daughter is about 3 years. Semicolon. That her husband is a SSB Jawan and they stay along with him outside Assam in different outside Assam as well as in different places of Assam. That they stayed in Gusaigaon and thereafter at Mongoldoy. That during their stay with him, her husband harassed her and her children both mentally and physically. That on 25/7/2025, her husband, after returning from home, threatened to kill her and her children, which compelled her children and her to leave the house in Mongoldoy to their to her parental house situated in Tilikigam, semicolon. That her elder daughter informed her that during their stay in Gusaigaon and Mongoldoy since the year 2023, the accused applicant used to rape her under threat and threatened her daughter not to disclose the same to anyone. It was alleged that out of fear and threat, she did not disclose the same to anyone. On the receipt of the FIR, the police registered Gula PS case number 110/2025. And after investigation, charge sheet was laid. Charge sheet was laid on
Page 27.
laid on 9/10/2025 before the trial court. Wherein 13 PWs have been named by the prosecution. Full stop. It is then you write. Charge sheet was laid on 1910, 1910, right? 1910. Then charge was framed, then you write, charge was framed on 22/12/2025 until date, till 12/6/2026. Two witnesses, that is the informant and victim, have been examined before the trial court. The TCR in the instant case has been received and the same is perused. The learned counsel appearing for the accused applicant submits that Learned Counsel, Mr. N.J. Dutta, submits that the story that has been narrated in the FIR is totally unbelievable, and in fact, comma, the accusations have been made by the informant against the husband, that is the accused applicant, due to she having an extramarital affair with another person. He further submits that since the victim girl and the informant have already been examined before the trial court, at this stage, trial court, and the accused applicant has spent more than how many days? More than
From 23/8/25, 1 year.
About 1 year, behind the bar. He should be granted bail at this stage. He submits that the accused applicant shall cooperate in the trial process and shall not try to influence any of the witnesses, whatsoever. On the other hand, the learned APP submits that there are sufficient materials. There are sufficient prima facie materials against the accused applicant. Full stop. He submits that trial has just begun in time, and only 2 witnesses have been examined, and some vital witnesses are yet to be examined. Therefore, he opposes the prayer of bail of the accused applicant. Full stop. Mr. R. Hazarika, the learned counsel, appearing for the accused, appearing for the respondent, appearing for the informant, that is respondent number 2, has also supported the submissions made by the learned APP. Full stop. The TCR that has been produced before this court is perused, and the submissions made by the learned counsel appearing for the respective parties have been considered. It is seen from the records that the charge sheet was laid down on 19/10/2025, and thereafter charges were framed on 22/12/2025. It is also seen that the last witness was examined on 17/4/2026, which includes the victim and the informant. Full stop. It is therefore it is seen that after submission of the charge sheet, the trial has proceeded in a reasonable good pace. Full stop. Good pace, reasonably good pace, and expected to be completed soon. Though there are about 13 witnesses altogether, out of which 2 witnesses have been examined. In this connection, the observations of the Honorable Supreme Court may be relevant, which are extracted herein below. You write para 14, extraction para 14. Ordinarily, in serious offenses like rape, murder, dacoity, etc., once trial commences, the prosecution starts examining its witnesses. The court, you write about Supreme Court in the case of X versus State of Rajasthan, reported in 2024 Supreme SC 1106, may be relevant, then extracted here and below. Okay. Then 14 we have written, starts examining its witnesses, the court, be it the trial court or the high court, should be loath in entertaining the bail application of the accused. Para 15, over a period of time, comma, we have noticed two things. That is, one, either bail is granted after a charge is framed and just before the victim is to be examined by the prosecution before the trial court, comma, or two, bail is granted once recording of the oral evidence of the victim is complete by looking into some discrepancies here or there in the deposition and thereby testing the credibility of the victim. Para 16, we are of the view that aforesaid is not correct practice that courts below should adopt. Once trial commences, it should be allowed to reach to its final conclusion, which may either result in the conviction of the accused or acquittal of the accused. The moment the High Court exercises its discretion in favor of the accused and orders release of the accused on bail by looking into deposition of the victim, it will have its own impact on the pending trial when it comes to appreciating the oral evidence of the victim. It is only in the event if the trial gets unduly delayed and that too for no fault on the part of the accused, the court may be justified in ordering his release on bail on the ground that right of the accused to have a speedy trial has been infringed. Taking into account the factual matrix involved in this case and the observations of the Honorable Supreme Court, it is seen that the trial in the instant case is not unduly delayed and the same is going on in a right speed which is expected to be concluded soon, bringing in the logical conclusion of the trial. Taking into account the aforesaid, this court is not inclined to grant bail to the accused applicant at this stage. Accordingly, the instant bail application is rejected.
At this juncture, I am aware.
May I please your lordship?
As per official, my lord,
Hmm.
7 is my lord. Can copy of this year along with CD notice.
Mr. MS BRA Sultana is present for the petitioner, for the accused applicant, accused applicant. Mr. B Sharma is, APP is present for the state. Trial court record along with the CD has not been received. Let the matter be listed. When?
In last week of August, my lord.
Hmm?
Last week of August.
Hmm?
Last week.
Last week of
August.
August. Okay. Let the matter be listed on 27th August.
No, sir.
27th August.
So
21.
Do কি হল পাঁচশো মাস হল না নাসিল এটা মানে অর্ডার পাস করা হয়েছে after 3 weeks after 3 weeks অর্ডার পাস করা হয়েছে এটা হ্যাঁ একদিন অর্ডার পাস করা হয়েছে আগে কি লিস্ট করেছে এটু নহয় জানো এই মানটো কোন পৰা ওলাইছে এই স্ক্ৰিনত যে মানটো ওলাইছে তাৰ কেছটো অৰ্ডাৰ পাস কৰা হৈছে স্ক্ৰিনত হয়তো বেলেগ নহয় মই এইটো ঠিক আছে
May it please your lordship.
Yes.
Lordship, it's an anticipatory bail application under 482, lordship. The interim was granted on 7.
CD has come.
Notice, but as per information, search submitted.
Tarsi submitted, you go there.
Yes, lordship.
Heard MSJ Das, the learned counsel appearing for the accused applicant. Also heard Mr. B Sharma, the learned APP for the state. This is an application under section 482 of BNSS, praying for a granting anticipatory bail to the accused applicant in connection with Haflong PS case number 61/2025 under sections 318 in bracket 3 stroke 336 bracket 3 stroke 338 of BNS 2023. A coordinate bench of this court by disorder dated 22/7/2026 has granted interim pre-arrest bail to the accused applicant. No, she has not appeared.
Mine did not appear, my lord.
Then what search sheet you are talking about?
Because, Abu Rahman evading hiding himself from police arrest, however, he got booted, my lord. Until that he has not appeared before the IO for recording his statement, my lord. That's not so.
Then that's what, then why you're saying charge sheet, charge sheet, charge sheet? How it is connected with charge sheet? Charge sheet was laid earlier only.
Mine. I think they have as in the report we found that there is not co-party, my lord. Actually, in the last copy, the lordship was supposed to appear.
Lordship, the two accused person were there in the present case. My wife was also connected in the present case. For my wife, charge sheet has been laid, and for not for me. And I was asked to appear through video conferencing as I had threatened to my life, Lordship.
What threatened life? Who threatened you?
Actually, when the accused was about to go to the police station and he got down from the train, he was attacked by a mob, Lordship. And on 4/2/2026, our order was passed by this honorable court that I should appear through VC. But the investigating officer is not cooperating. Despite my learned senior advocate PP, public prosecutor has also appealed the investigating authority. And also we intimated the investigating authority through call as well as through messages. But there was no reply from their end, Lordship. This is the actual fact.
But this was on the earlier occasion only.
Earlier occasion.
What is the latest? Have you tried again? Have you tried again? Have you written to the this thing IO? Where is your written application to the IO?
At present,
Order. Order was passed in the month.
22/7, I guess. 22 or 27.
Have you tried? Have you tried?
That I have not written to the IO, but before that, before 22/7/2026, which the matter was listed when last listed.
Are you
before that.
excused from appearing?
No, Lordship.
Then
Actually, the accused person also tried again through contact through phone call, Lordship, but we have not sent any representation.
then we'll cancel your bill.
Lordship, a last chance may be granted, so I can just send a representation at least. Because the IO is not
Our city is not against you. Only
against me,
on-
against my wife. Even my wife, when she was in police custody, she was tortured, Lordship. This is the actually I have threatened to my life. Otherwise, I would have appeared before the IO.
Where have you stated that you have threat to your life?
It is not in the bail application, but I stated verbally, Lordship.
Verbally, I mean, who will believe this?
On 4/2, order was also by this honorable court.
No,
So
I
that-
understand the order has been passed, but I am not believing that your story.
because after
I am not believing your story. Where is that? I mean, that you have written to them. Where is your application? Have you written to them?
I have written to them previously, Your Lordship. I
After
also
that order, my lord, what will happen after that order? I could directed him to appear before the IO for PC only.
I have a 30th April message, Lordship, to the Haflong PS.
No, after that order, in last order. In the last order. That's not something you can take, which is-
Mr. PP, additional PP, you take instructions, why the facility is not big, there is an order from the court. Why this is not facilitated? It should have been facilitated, correct? Why you are not facilitating her? Because there is a direction. Have you not produced that direct order to the this thing? You have sent this order, no?
I have sent this order. I have this last order. I have sent the 4-2 order, which was the first order for VC. Thereafter, it was also directed that this order should be sent to the public prosecutor also. In the last order, it has been mentioned.
See, the problem is that charge sheet is not filed against her, against against the person, right?
When established against the accused person, Nurjahan Begum, Jyoti Burwa, so I submitted charge sheet so and so, upon so and so, against the arrested accused person, Nurjahan Burwa, before the honor court trial. On the other hand, the case is kept open. Case is kept open. As the accused Atabur Rahman was evading hiding.
Is
Evading hiding himself from arrestment. It is a abscond matter.
But Lordship, I am at my own residence only. I am not absconding because I am on interim also. So I'm not supposed
have you
to.
appeared? I mean, Atabur, he appeared.
He tried to appear on the previous occasion, but as
No, who is this lady or that Atabur?
Atabur Rahman. Atabur, this present bail, anticipatory bail application is against Atabur Rahman.
He is not co-participated.
Oh no, and this is only Atabur Rahman.
Only Atabur Rahman.
You find out, I mean, why this facility is not given, because there is an order from this court. We'll fix it. We'll fix it in the next week. Heard MSJ Das, the learned counsel for the accused applicant, also heard Mr. B. Sharma, learned APE for the state. In terms of it is submitted by the learned counsel appearing for the accused applicant that though the accused applicant had tried to appear before the investigating officer by video conferencing, the same was not made possible due to non-cooperation of the investigating officer. In view of the aforesaid, the learned APP is directed to take instruction as to the allegations made by the counsel appearing for the accused applicant. Let the matter be listed in the next week. Next week on 18th. 18th, you find out what is happening.
Lordship.
Driving item 43.
Your Lordship, I believe the second petition line. Your Lordship order is page 42 earlier order. The matrimonial dispute, my lord, the matter already settled in the court of law, my lord, in the family court. Page 42, initially they got interim order, they appeared, they cooperated. And that was, my lord, FIR was not available at that time.
Yes,
My kindly see page 41 also, my interim order. At that time, FIR was not available, my.
no, that fine, the FIR was received, then case diary was produced, then it was.
After interim order, the FIR was there, registered the FIR, my. After interim order.
Correct, though registered FIR, then the CD was received,
CD was.
after perusal, it was rejected.
Now kindly see also the FIR, madam. Whether
FIR I have seen.
all the persons, madam. You will kindly
Now
see.
you're saying that there's some settlement, what settlement happened?
No, settlement, madam, maintaining his case that there was an agreement, compromise agreement.
After the settlement, only the dispute arose.
No, this, I am not saying this, madam. Matrimonial dispute, madam.
That is settled.
Husband and wife. Now all other persons have been also entangled. I am only one that at this stage, madam. Father is 70 years old, madam. Mother is also there. All brothers, all are involved. The allegation you also kindly see the FIR only once, madam.
FIR I have read, just now I have read.
FIR kindly see, madam.
I just
All,
know
I think, madam, these sections, all are not, cannot be made out in this. At least, madam, I fairly submit, number one, may have, madam, he has done something, madam. So for number two is my 70 father, my lord. And number 5 is the mother. 3 and 4 are brothers of the number 1, my lord. At least for these persons, I say, my lord. About one, I have nothing to say, my lord. I think your worship. But so far, these persons concerned, as per FIR also, there is not that allegation which, my lord, requires them to be taken to custody, my lord. As per page 15, my lord. And actually, he has tried to bring his son, my lord. Not the. Only other persons, my lord, I am going to say.
Wife can't do anything with the help of the family.
Madam?
Wife can't do anything without the help of the family member.
Madam, so far criminal part is concerned, family matters, it happens, my lord. Family matters, it happens sometimes. But the education which is, you know, like kindly see, madam, whether that is on the face of the FIR, madam.
So who has filed it FIR?
FIR
was filed by one.
Wife of number 1.
Huh?
Wife of number 1.
Mizanur Rahman is who?
Mizunal is the husband of informant.
He also filed it FIR.
He also filed a file that was not registered. And this case was registered after 17 days, madam. Only when this report has gone from this court, madam.
Then another witness matter, another witness who rescued matter.
No, the allegations against number 1, madam, all the allegations. Page 37 is the FIR filed with the present petitioner.
No allegations against the other persons. Nothing is there.
going to the inform to the House of the Mandate gentleman. It's on two parties here. Upon the statement of the complainant is reported. Case number 224 explains me on the way and attempted to appraise my modesty by attacking on me as well as pulling my clothes.
Father-in-law, my lord, 70 years old.
Other persons like the other persons. One, nothing can be done.
That one I found something.
Lord Mr. H.R.A. Chaudhary, the learned counsel, senior counsel, assisted by Mr. Soinsu, the learned counsel, appearing for the accused applicant, also heard Mr. B. Sharma, the learned APE for the state. He is an application under section 482B of BNSS 2023, praying for granting anticipatory bail to the accused applicants in connection with Balpeta PS case number 137/2026 under section 109-1/126/2/117-2/351-2/351-2/5 BNS 2023. An FIR was lodged on laws on 14/4/2026, alleging entirely that on 14/4/2026 about 7 p.m. the accused applicant number 1 took the informant's 8-year-old minor son Dildar Rahman from the front yard of her house on the pretext of giving in the pretext of buying some chocolates from the nearby shop. Semicolon that the accused number 1 took his son to an isolated place and tried to strangulate him. And after that, he was thrown to a pond. It was alleged. It was also alleged that when the child made hue and cry, and the accused person fled away from the place of occurrence. After receipt of the FIR, the police registered Balpeta PS case number 137/2022, Galak paragraph 137/2026 under the aforementioned sections. The learned senior counsel appearing for the accused applicants submits that there are no allegations against the accused applicant numbers 2 to 5, who are the family members of the accused applicant number 1. He submits that since they are not involved in any of the offense that has been alleged in the FIR, this would be granted pre-arrest bail at this stage. He submits that he is not pressing for. You are not pressing for Mizanur.
No, one I am not. No, I'm pressing what your lordship. That will give you a wrong message, man.
The accused applicant should be granted pre-arrest bail. The learned APP, on the other hand, opposes the prayer of the bail applicant, prayer of anticipatory bail to the accused applicants. The CD in the instant case has been received and the same is perused. After taking into account the submissions made by the learned counsel appearing for the respective parties, as well as on perusal of the CD, this court is of the considered opinion that accused applicant number 2 to 5 should be granted pre-arrest bail at this stage. Accordingly, it is directed that the accused applicant numbers 2 to 5 shall be released in the event of arrest of the accused applicant number 2 to 5. This will be released on furnishing of bail bond of rupees 20,000 each with security of like nature with the satisfaction of the arresting authority, subject to the condition that the accused applicants number 2 to 5 shall appear before the investigating officer within a period of 7 days from today. Then the accused applicants number so and so shall cooperate with the investigation and make themselves available as and when called for by the investigating officer. Accused applicants shall not try to influence or tamper or hamper with the investigation in whatsoever manner. Full stop. Full stop. Next para. As far as the prayer for anticipatory bail of the accused applicant number 1 is concerned, the same is rejected. In terms of the official direction, the instant AV application is disposed of. CD to be returned.
They will appear within some particular day.
7 days. Number 1 is rejected, others granted anticipatory bail.
If he's satisfied, my lord, he's. But some with it.
Timing at 17. 17.
And here, charges have been.
Who is appearing for 17?
And the idea of question also non-repeatable. First call.
No, one lady was there. She mentioned in the morning. But then we said that charge sheet is submitted, so we'll wait for some time.
46.
TDS come?
No, minor, CD not.
I am on interim, petition number 4 is only on interim, others are not on interim, lordship.
Let the CD come and we'll decide then.
Shorter date, lordship.
Okay, heard Mr. S. Krishna by Learned Counsel appearing for the accused applicant. Also heard B. Sharma, the Learned AP for the state. CD is yet to be received. Interim order passed earlier, shall continue till the next date of listing. Interim order against 4. Interim order as far as petitioner number applicant number 4 is concerned, the same will continue till the next date of listing. Let the matter be listed on 24. Earlier.
That is, can you do 20 for whatever lordship, not
20.
deeply well.
37.
CDS come? Yes. Yes.
At page number 8, madam.
Page
8.
Yes, CD. What is that?
One person has been arrested, one Nagpur are legal. And from each statement, whether each person is implicated that another two persons are there along with him, one is another person, and one of them is also guarantee persons are there.
Only statement of the arrested person.
So, who will, otherwise how the police will get to know? Only from the statement only people will get to know. Otherwise, are you going to are you going there to say that I have done it? Somebody has to tell it. CD, what is there?
And in the CCTV footage, my lord, in the forwarding report of photography.
Heard Mr. R. Ali, the Learned Counsel. H.A. Ahmed, the Learned Counsel appearing for the accused applicant. Also heard Mr. MP Goswami, the Learned AP for the state. This is an application under section 482 of BNSS 2023. Praying for granting pre-arrest bail to the accused applicant in Hatigaon PS case number 211/2025 under section 61. In bracket 2, stroke 318, bracket 4, stroke 303, bracket 2, stroke 308, bracket 2, stroke 307 and 3138 of BNS. An FIR was lodged before the officer in charge, Hattigarh Police Station on 3/12/2025, that that the informant hired one e-rickshaw, wherein 3 passengers were already seated, and that the rickshaw moved towards the Shizubari. Then the miscreants, the help of a handcuff, put something on her face, and she became unconscious. Thereafter, she regained consciousness in 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 mm, in near the game village, Later on, she came to GMCH and got herself examined, and she was released after that. She found that several monetary transactions from her card were done by the miscreants by using her debit card, and they have stolen an amount of 1,69,000 rupees from by the same poster. Police on receipt of the FIR, police registered Hattigarh PS case number 2002011/2025 under the aforementioned sections. To supply learned counsel appealing for the accused applicant submits that he is not involved in the offense as alleged in the FIR, and in fact he has been named by one of the person who has some enmity with him. Full stop. Case diary in the instant case has been received, and the same is perused. On perusal of the case diary and having found prima facie materials against the accused applicant, the instant AB application is rejected. Yes. Did you receive? Yes.
Lord, pre-arrest bail application, my lord. Lord, your lordship will find the FIR at page 14, my lord.
Page
16. My lord, this is, my lord, there was a love affair between the, my lord, victim and the petitioner, my lord. There was a love affair between the victim and petitioner, my lord. The petitioner, my lord, took some photographs of the victim, and thereafter, my lord, he pressurized her to marry him. And thereafter, my lord, the victim, she cut off all relation with him. And the petitioner threatened her to, my lord, viral the photographs in the social media. And my lord, out of embracement and my lord fear, my lord, she consumed poison, my lord. This is the allegation, my lord.
Difficult.
CD will reveal that book, my lord. Whether he is involved or not.
Pressurizing the victim, my lord, for solemnizing the marriage, my lord.
Give me the CV first.
Only, my lord, his involvement is he pressurized her.
Pressurized higher by taking photographs, and we know what kind of photographs it would be.
They are the same.
You are not taking her, the normal photograph.
She could not be same.
But when the photographs were taken, how? Because like she has been always refusing it. His parents are also refusing. Then when the photographs were taken?
That is the fact, madam.
That is the fact means where, how you are implicating him. The only FIR is very vague. I mean, the statement is vague. That means যোৱা ইংৰাজী ইমান তাৰিখে 1 বজাৰ শাহিন আহমেদে মোৰ ছোৱালীক তেওঁৰ লগত পলাই যাবলৈ বাধ্য কৰিবলৈ চেষ্টা কৰে। যদি তাই তেওঁৰ লগত নাযায় তেন্তে তাইৰ ফটো সামাজিক মাধ্যমত প্ৰকাশ কৰি বদনাম কৰিম বুলি ভাবুকি দিয়ে। But they have not met. They were not in a relationship. Only he wanted to marry her. Then how the photographs were taken? And now see, now somebody, I mean, somebody wanted to marry a girl, and like she refused, and her parents also refused, and after that she consumed, I mean, some poison, died, and like their parents will go and like file an FIR against that person. Okay, that person has proposed, so he must have done it, pressurized. Now you'll have to show something that like some direct link with the alleged commission of offense. You have a look in the CD properly there. There nothing is there. PM part will give what? PM part will give only thing is that okay, he has died of or she has died of poison. But how it will link to him? There is no allegation that he has bought poison or like he has put in poison.
That is the FIR also statement.
There is nothing, I mean, I'm vague in this thing, allegations. Heard Mr. S. Ahmed, the learned counsel appearing for the accused applicant. Also heard Mr. B. Sharma, learned APP for the MP Goswami, learned APP for the state. This is an application under section 482 BNSS for applying for granting pre-arrest bail to the accused applicant in connection with Murajhar PS case number 1102026 registered under section 61 in bracket 2 stroke 77 stroke 78 bracket 2 stroke 79 stroke 107 BNS Act 2023. The allegations as alleged in the FIR dated 14/6/2026 that the accused applicant pressurized the accused applicant proposed the informant's daughter for marriage. However, the same was refused. Full stop. The accused started. It was alleged that accused applicant started pressurizing her, stating that her photographs will be made viral if she is not married, if she doesn't agree to marry him. It was also alleged that due to such pressure, the complainant's niece, about 17 years, committed suicide by having poison, full stop. Where is the FIR?
Vernacular part,
At page 16, man.
because it will be more clear. চিনাকি লোক আৰু প্ৰায় আমাৰ ঘৰলৈ অহা যোৱা কৰে। সেই সূত্ৰে 1 নম্বৰ প্ৰতিকাৰখনে মোৰ ভতিজী তাকমিনা বেগমক ঘৰত ইমান চলেৰে প্ৰেমৰ জালত পেলাই আৰু তাইৰ ফটো সংগ্ৰহ কৰে। That is the lead.
There are certain allegations against him. Then it right, then, if I kill you last line. Being poisoned due to the fact that, the accused applicant, had taken certain certain confidential photographs, no, certain personal photographs of the victim girl, and he threatened the same to be made public, full stop. The learned counsel, appearing for the accused applicant, submits that the offense is alleged in the FIR. It has not been committed by him. They were in a law condition which has gone sour, and he's not aware why the accused applicant, why the victim girl has committed suicide by consuming poison. Full stop. He submits that the accused applicant shall cooperate with the investigation if he's given some protection. Full stop. Learned APP on the other hand opposes the pair of the bail. Full stop. CD has been received and the same is perused, and after finding prima facie incriminating material against the accused applicant, the interim, the prayer for interceptory bail is rejected. Is rejected.
Your Honor. My lord, that photographs is also
No,
not.
rejected that, there were, you have taken her photographs.
The FIR.
Okay,
based
I
on
have.
some-
Your
passed the
Honor,
order.
Your
I have
Honor,
passed the order.
Your Honor,
I have
Your
passed the
Honor,
order.
My lord,
Your Honor, item number 7.
photographs, my lord.
I passed the order. I thought of giving you, but I have found certain materials in the CD. I thought of giving you, but I have found certain materials in the CD. I can't be helped. I can't help
Your
it.
Lords,
It can't be helped.
When, my lord, he took
It can't be
photographs,
helped,
nothing
Mr.
there,
I told you that.
Not disclosed.
Don't argue after the order is passed, please.
Your Lordship, item number 7.
Yes, yes.
Item number 12, may
Hmm.
be taken up at 2:30, I have some
2:30,
2:30, no issue. When I have already taken.
2:30.
11, 12 and 13.
Okay.
Arising out of.
Your Lordship,
Have you filed any objection to that?
Yes, sir.
We are filing now.
We have already filed it.
Okay.
Your Lordship, item number 7. मुझे सुनाई नहीं
Item
पड़ा
number
था now.
7, item number 7, Mr. Counsel, no, Mr. What is your name? Chandramani Pathak.
Chandramani, yes,
Mr. Chandramani Pathak, we have already passed the order. The matter will be listed after 3 weeks.
सर दो लास्ट टाइम भी ऐसा हुआ था सर, वॉइस
तो
जो है
मैं
वो
कुछ नहीं
माइक
कर
की
सकता,
वजह से
जो
नहीं आया था
मैटर वो जो बुलाया गया, आप वो you were not there. I can't be helped.
सर मैं था लेकिन वॉइस नहीं.
CD not received, later matter will be listed on. Twenty, no? 21st. You are there.
39, 38. 39, yes,
39.
38 already rejected.
CD not received. CD not received. Mr. S. Ahmed, the learned counsel is present for the accused applicant. CD not received. Later matter 21st.
Obliged.
In the item 8, your lordship, we have filed this WPC, your lordship, seeking consolidation of the affairs pending against the petitioners in different places, your lord, districts, your lordship, on the ground that there is a CID PS case, your lordship, which is looking at the larger conspiracy, your lordship, regarding the activities of this particular organization. Now, in the meanwhile, I have been informed, your lordship, that in number of cases, your lordship, charge has already been submitted, your lord. Since our prayer was for consolidation of the affair, and in the meanwhile, it has some of the cases has your lordship, charge sheet has been filed, your lordship. Therefore, your lordship, I need to take instructions from my client, your lordship. Now, what will be the course of action available to us?
How much time?
2 weeks, your lordship, within 2 weeks.
Mr. S. Botakur, the learned senior counsel, appearing for the petitioner, petitioner, raised for 2 weeks time to take instructions for his, from his client regarding the issues involved in the incident case. Full stop. MS, yeah, you thus, senior government advocate, additional senior government advocate is present for the state respondents. And you also agree for? Okay. Let the matter be listed after 2 weeks.
Otherwise, your lordship, the pleading is complete.
Pleading
You
is
will not
complete.
file any reply, your lordship.
You want the clubbing of the matter, sir?
No, plugging of the affair. With the CID PS case. PS.
The CID is the first case.
That was not the first case, that was the second case, but it has your lordship looking into the larger conspiracy, your lordship.
How many cases filed?
Your lordship, here are 9 cases here.
9 cases.
Thereafter also cases here.
Your ground is what? I mean, for consolidation?
Ground is that your lordship, since a larger conspiracy is looking into by the CID, and if we go through the CID FIR, we will find that they have mentioned about the activities of this particular organization in every district, your lordship, of the state. And therefore, when the larger conspiracy is looking into by the CID, there is no question of the smaller conspiracy to be investigated.
So basically, sameness of the allegations.
Victims are different from different places. And though organization is same, but persons involved in all the activities are not same. So it is not possible to club by CID. We have already given the detailed affidavit.
Okay, we'll consider this. We'll consider it.
Yeah, please. Item number 9, in this case, I am the private personnel, but I have seen the notification alert, they have taken time for the petition.
Item number?
9. Mentioned. I am not informed your lordship. But on the other hand, your lordship is still there, your lordship. No maintenance has been paid to me, your lordship. And the 80% I have assigned, your lordship.
We have already passed the order. I mean, when the matter comes next, you please raise your issues. Item number 9 just mentioned. We have already signed it probably. I mean, it should have come earlier then.
No, I am sitting from the 10:30 a.m. So I did not see. After 4 years, that's I could not see them.
Okay, you write it there. Make his present. Because PP was there, you are respondent number 2. So, I mean, maybe I don't know whether they have stated what order I have passed. I don't remember now. I don't know whether they have stated consent or not. Okay, we'll record your name. Item number 9. Just record his name. He is present.
So the petitioner before your lordship is the accused person in a 138 Act proceeding, my lord. And the PWs has been examined, cross-examined, and the 313 statement of the accused has been recorded, my lord. And the accused person has relied on stated certain specific facts which
PCR is not required.
Below.
PCR is not
PCR
required.
may be required, Mila. The impugned order is page 22.
PCR is, not called for.
Milord, on the first day of motion, your lordship was pleased to direct that they let the other party required appear, and after that the stay may be considered in this case.
So TCR will be required in this case.
Yes, Milord.
No such order has been passed.
Yes, my lord.
Mr. Borthakur, TCR will not be required in this case.
normally TCR is called for.
TCR will be required in this case. TCR is not called for.
Yes, my
So
lord.
we'll call for the TCR and fix another date.
Till then, my lord, the proceedings may be stayed.
No, no, that can happen without hearing. I mean, how can it be done?
My lord,
When is the next date?
this month, my lord, yeah, on 20th, 29/8, my lord.
So we'll put a date before that. We'll call for the TCR and on examination the TCR only will do. I don't know whether it was not pointed out to the court that TCR will be required. So there was no order passed on this. Heard Mr. A.K. Sahu, the learned counsel for the petitioner, also heard Mr. S. Borthakur, the learned senior counsel, assisted by Mr. Huh? D. Sakya, the learned counsel for the respondent. Registry to call for the TCR. TCR in connection with NI case number 135 or 20215, right?
Yes.
From the court of the learned additional chief judicial magistrate Dibrugarh. Let the matter be listed on registry call for scan copies. No? Scan copy with PCR. So, let the you are saying 29th.
29/8.
Let the matter be listed on. It's from Dibrugarh, so it will take some time. Yeah, thanks. Okay, let the matter be listed on 25th.
25th.
Huh? 25th August.
Again, for the orders.
Made please, your lordship. It is an appeal against conviction. Conviction is under section 10 of POCSO and 448 IPC version. And sentence is of 5 years.
As for order, I think 16/7 fixed for hearing.
The IA is pending, so perhaps that's why it's coming, orders come.
Yeah, this is already fixed for hearing. This was wrongly listed. I mean, paperwork will not be required in this case.
5 witnesses.
Huh?
Only 5 witnesses. 6 witnesses.
Below 10 years.
Yes, it's a short record.
5 years and
5 years conviction. That was why I was praying for the suspension, because.
okay, we'll fix it for hearing then. Your matter will be heard together. Okay. Heard Mr. A. Atria, the learned counsel, appearing for the applicant stroke appellant. Also heard Mr. K.K. Parasar, the learned APP for the state, as well as Mr. RSA for respondent number 2. For respondent number 2. Let the matter be listed for hearing after 2 weeks.
So perhaps a day.
Let the matter be listed on first week of September. Let the matter be listed on 3rd of September for hearing.
May I please speak to your lordship? Lordship, on last occasion, service, it's still awaiting for, on behalf of respondent number 2, lordship.
Sorbet report hasn't come back as yet.
That the interim bail should continue, lordship. Interim bail should continue.
Interim order was there.
No.
Where is the interim order?
The petition is an interim bail, lordship.
Okay. IA, you write service report on respondent number 2 is awaited. Interim order of suspension of sentence and previous sentence on previous bail shall remain force till the next date. Release the matter on release the matter on first week of September sometime or 8th of September. 8th of September. In criminal appeal you write service report on respondent number 2 is awaited. Then you write TCR not received. TCR not received. Register to send a reminder for the TCR. Let the matter on along with the IA on what was the date I have given?
8.
9 or 8. 8.
Grateful.
8th of September.
42.
None appeared for the petitioner when the matter was called for. CD not sorry, okay. Neither the AD card nor unserved notice in respect of respondent number 2 has been received by the section. Till date, let the matter be listed after 2 weeks.
May I please, your lordship. Lordship, steps was taken upon respondent number 2. In the IA, there is a delay of 315 days. And there's an office note, lordship, dated 5/8/2026. The registrate handed over to the PP office. Steps. Already taken.
MS LDB is present for the LDB Learned Legal Aid Council is present for the applicant. Service report. Service report as regards service of notice upon respondent number 2 is yet to be received. Let the matter be listed after 2 weeks.
Of license.
তো তাকে একটু হানা যায় বেলেগ কি আছে এডমিশন সেইটা ফিক্স করা কেইটা আছে হিয়াৰিং কেইটা মাতিছ নে তাৰলৈকে চাওঁ কি
44, hearing. Well, in this case, Sanskrit record has to be confirmed.
Record was hold for Anna, but
Hmm?
it has not arrived.
Hmm?
CD and the TCR was hold for Anna, but it has not
Hold for?
arrived yet.
Mr. So-and-so, the learned counsel is present for the petitioner, as well as Mr. K.K. Parasar, the learned APP for the state is present. TCR is still awaited. Let the matter be listed after 3 weeks. After 3 weeks.
45 and 46.
I'm applying for 46 lordship. He's on legs lordship. Kind of after some time lordship. I can know for 46 lordship.
46.
Yes, lordship.
Item number 46, you write MS so-and-so is present for the appellant.
Yes. He's on legs lordship after some time lordship.
After some time, it will be difficult. Today, there is some other matter fixed.
He's coming on the way lordship.
You were saying he's on legs.
Yes,
Then
sir.
he was saying he's coming on the way.
Because
Two statements cannot go all together.
called him
He must be he's I mean like we have seen Face Off kind of same movie. I mean like split personality or what. And he can be there in both places. It's not exactly split personality. That's a different concept, but he's coming now.
45 lordship. I know 45.
Now she's saying that you are on legs.
45.
Then again, if she's saying that he's coming. Now I don't know which statement we should take.
No, actually, as in quote number 25, I was just come here seeing the court of this matter.
No, I'm not saying anything about you. I'm just asking what you see.
Well, actually, there are two cases there, my lord. One is, my lord, the jail appeal, my lord. In this case, initially, I was appointed as an amicus for
No,
the,
I mean, the paper book is not required in this matter.
we have got a copy of all the evidence, my lord.
What is the punishment?
Punishment is, my lord, no, my punishment is 5 years, out of which the appellants have already undergone close to 4 years. And the appellant that I am representing, my lord, as an amicus, she is suffering from AIDS, my lord. So one of my submissions would be, my lord, that even if the conviction is upheld, whatever terms she has undergone, that could perhaps be set off. That is one limb of my argument. Another, my lord, in
That will depend on the merits of the
merits
case.
of the case, my lord. Another aspect is, my lord, in this case, this is a case of NDPS, my lord, intermediate quantity. So the body search of the appellant was done, my lord, and a section 50 notice was issued. But there is a problem with the section 50 notice. The section 50 notice would require that the victim, if the victim waives her right to be searched in front of a gazetted officer, then the police can search and that search will be legal and that will be admissible. In this case, my lord, the notice, my lord, section 50 notice, it's a template in which it is, my lord, written like this, my lord. I couldn't get, it's there in the record, my lord.
Those things were discussed by the trial court.
That issue was not examined, my lord. Section 50 issue, that was not examined, but section 50 would form the crux of the case, my lord, because this was recovered by way of a body search, my lord. Well, I'll go into the depth of the case, my lord. That's the one point I'm pointing out, that in the notice under 50, it is written that I have been informed and I have understood the notice of personal search under section 50 of the NDPS Act. I require, do not require that my personal search be conducted in presence of the nearest gazetted officer or magistrate. There has to be a specific waiver from her part. Now they have just relied on that template format, my lord, the police. Even there is not even tick on the part that I do not require. So unless and until she personally waives her right to be searched, then the search becomes illegal, my lord, and whatever recovery is subsequently made, that becomes inadmissible.
Just the fact is that, madam, yes, copy, even like copy is not perhaps maybe I will take a copy from him. There is another thing. And regarding madam, in item 45, there are 3 persons. In item 46, there are 3 persons. So 6. Now out of 6, one is by age. So regarding that person, madam, that lady will take an instruction from the jail authority and everyone. For the others, it has to be in merit, madam. So, madam, yes, short.
In fact, we are ready today, your lordship, and it can be disposed because only a short point is involved regarding compliance of section 51 was whether it was followed or not by the prosecution. That is a simple question.
That is the one. I don't have the problem.
In that case, I'll give a copy, my lord.
I think that copy is not because of that. Otherwise, we'll examine that matter on only that.
As far as like his contention that she has already spent more than 4 years and she's suffering from AIDS.
One is suffering for AIDS. Others, maybe on me. So,
3 of them are on bail. I am informed 3 of the they are on bail.
Rest, except Guria Devi, all are on bail.
Only I'm appearing as an amicus for the jail appeal, my lord. So that person is not on bail. All other persons are on bail, my lord. The only reason why, my lord, I was submitting, because otherwise they can wait because they are on bail. Because this person is also sick and at the same time she is also in jail, my lord.
So let them take instructions then. I mean, you take instructions from the jail authorities whether suffering from AIDS or not, whatever.
That is also something, my lord, I only found in the record.
So let him verify it. I mean, whether it's there or not.
I'll also furnish a copy, my lord, of this evidence and everything for my learned friend.
So should we record something or like, or you take the? Okay, right. Heard Mr. S. Nawaz, the learned counsel, appearing learned amicus curiae. Amicus curiae.
In criminal appeal, A 107 of 24.
2024.
For appeal number 1.
for
Appellant number
for
1.
appellant number 1. And Mr.
As Dr. for.
as
appellant
Dr.
number
for
three.
appellant number 2 and 3 and Mr.
Jed alone.
Huh?
Jed alone.
Jed Alam for respondent number.
Item number 46.
Oh, that is item number 46. Okay, 46 is which, what is the number? Criminal appeal number?
Appeal number 398 of 2020.
Then you pass this order here, huh? This 107, the number 1. Then Mr. Nawaz submits that that the appellant number 1, who has been sentenced, who has been convicted and sentenced for
5 years imprisonment.
5 years RI.
Rigorous imprisonment.
5 years RI has already completed more than 4 years. Is it true?
Well, not exactly 4 years, my lord. I'll just compute, my lord. Around 4 years, my lord. Around 4 years.
Has completed around 4 years
12,
in 4 years in jail. 4 years in jail, and she is suffering from she is suffering.
HIV positive.
She is HIV positive. Full stop. The learned APP, Mr. KK Prasad, learned APP submits that he doesn't have any information whether the appellant number 1 is suffering from HIV. Mr. Parasar pays for some time to take instructions from the jail authorities about her illness. Let the matter be listed after 2 weeks. After 2 weeks on a date to be fixed by registry. Mr. Doctor is also there in the matter only, no?
I'm in the item.
Other matter.
Yes.
Other matter. Then you write in the other matter, Mr. Doctor is present.
Mr. Doctor is in my matter, my lord.
No, that's what I'm asking. What you are saying, other matter.
No. 45. Item
Then
45.
Mr. Doctor is also present for 2 and 3. 2 and 3.
2 and 3.
2 and 3. So this matter will be listed after 2 weeks. We are on a date to be fixed by the registry. And the other matter also, Mrs. Jed Alam is present for the appellant numbers.
All
All the appellants.
Item number 46.
All the appellants. For the appellants, Mr. Parasar is present and APP is present for the state. Let the matter be listed along with this matter only. After
Period
10
and
days.
completed, my lord.
Huh?
3 years and 8 months, my lord.
3 years and 8 months, that period. 3 years and 8 months. Achha, that matter, what happened to that matter that you were arguing?
My lord, the reference matter, my lord.
Reference matter?
The delivery of order tomorrow, my lord.
Tomorrow?
Tomorrow.
Okay. It heard only.
Already heard, my lord. Last Friday. Leave loaded.
Okay. None appeared for the appellant when the matter was called for, though Mr. B. Sharma, the learned APP is present. Let the matter be listed after 3 weeks.
In this matter, I'm led by senior counsel, Mr. Z. Kamar, madam.
He was here. Mama. Some difficulties today.
My lord, actually.
Number of occasions they have sought for
Hmm?
number of occasions they have sought for argument on the same ground. Sorry, senior counsel is from somewhere. Yes.
Yesterday he was in Shillong, my lord, so I could not be.
That matter has been stayed. The question of the charge sheet.
Okay, some other time then he's having another matter also. Probably he's prepared for that, which is coming up.
The date may be fixed.
Heard Mr. N. Kolita, the learned counsel, appearing for N.K. Kolita.
Yes, ma'am.
N.K. Kolita, learned counsel, appearing for the petitioner. Also heard Mr. Jed Alam, the learned counsel, appearing for all the respondents.
Right.
Huh?
No, respondent number 2.
Respondent number 2.
Yes, so,
Okay.
one,
Okay, Mr. B. Sharma is learned APP is for respondent number 1. Mr. Kalita submits that he is led by Mr. Jed Kamar, the learned senior counsel in the instant case, and Mr. Kamar is having some personal difficulties today. Therefore, praise for listing of the matter. When? After 2 weeks.
no, September, aspects.
First week September, okay, you put it on, let the matter be listed on 10th of September.
Give you.
Charge sheet has been filed in this morning. No one is there. no? None appeared for the petitioner when the matter was, none appeared for the accused applicant when the matter was called for. Though Mr. B. Sharma is, learned APP is present. Let the matter be listed day after tomorrow, concert date or date. Let the matter be listed on change. Day after tomorrow.
Fine.
Take it a matter. It is on record, not. Hmm? No, what, they wanted to come at 2:30.
Yes, sir.
Wait for some time. You be there.
Yes.
Who is appearing for the petitioners? Petitioners.
Mr. Bora is on his way, madam, after something. Ran Bora is on his way, madam, after some.
On his,
On his way, he's coming, madam, after something.
there is no other matter. Matter was fixed at 2:30. Okay, we'll take it up after. 10 minutes. We'll take it up after 10 minutes. I'll
Right.
just come back. 10 or 5 minutes.
The Lordship may hear on the matter of interim orders, my lord.
No, I mean, like, I have not gone through this. I mean, that is not, there was not on
Objection
record.
is regarding that. What is their plea?
No,
or
what
objection
is the objection? I'll have to read.
My lord.
I'll have to go through it.
If I may,
So whether we can take it up today,
No, not, your Lordship, up to your Lordship. I'll not-
because we want to go through it. What is
Definitely,
there?
my
What
lord.
is, where is that objection?
Manoj, I have not received the objections, Manoj. I am appearing for the petitioner in item 12, item 11 and item 13.
He hasn't received as yet. Hmm?
We have given them this card.
Okay.
They have served the copy to us because they has to receive.
Hmm.
So he is the only.
It seems like it has been handed over to your clerk.
Kindly get it from him.
No, Manoj. I have confirmed from my local counsel who was
Come
there.
down.
I haven't received, Manoj, if the prosecution, Manoj, the
No,
respondent.
they have
can
filed it
serve-
today only. They have filed today only, right?
And served it to his clerk.
They have filed it today.
Give me the mail address.
So, because, do you have a local counsel here?
Manoj, I'll contact it, but Manoj, if I may request the respondent, if he can serve me through email, I'll drop my email on chat box.
One Orup Rudropal.
Arup Rudropal is your clerk?
No.
No, she is my local counsel,
Local
Manoj.
counsel.
Yes,
He has
yes.
been given.
And clerk has been submitted. We could not find this lawyer, my lord.
Okay.
So-
That has been given to the clerk, it seems.
Manoj, I'll coordinate with him, Manoj, if I may make a request to the respondent if he may supply me through email. It's
It
my
has been
sincere
already
request.
given to your clerk. You have an appointed clerk here. So you contact
Yeah.
with your clerk and get it from him.
Manoj, I'll do that, Manoj, I'll do that.
So when do you want the matter to be listed? Mr. Bora, are you going to file any reply to that? There is no requirement.
I know what I have gone through, my lord. It's a matter of records, my lord, nothing else. They are pleased that I may liquidate the
liquidate the properties, you know. That is their standard. Apprehension, you know.
Hmm.
That
Now, what is the status there? I mean,
Status, my lord, 7 witnesses has already been examined.
how many?
87.
87. And how many are there?
Of course, out of 394.
394.
Because we have up and down.
And what is the expected time of completion of that?
Within 3 months, because the main witnesses will come from Singapore in the month of October.
well, this is during the witnesses are Caesar witnesses, those who are filing FIRs throughout the Assam, more than 100 FIRs are there.
We are not.
Are not examined, there are some other, basically these are only the Caesar witnesses and my lord,
But thing is that like any result of this petition may have some impact on the trial.
no, nothing, my lord.
Why?
Why? The reason is this, my lord.
Why? There is an accused, his property
No,
has
I'm
been.
not an accused, my lord.
There,
Here I'm.
I'm talking about the trial.
Okay.
The trial going on there. So trial going on there, you are an accused, correct?
No, I'm not accused.
He's not the
I'm not
accused.
Petitioner in item
What
11.
has happened,
item
Milan?
39.
I'll just shortly briefly I'll tell you that I am the petitioner before you, neither I'm an accused nor. I have opened a water bottle drink factory, and there one of the accused, that is Siddhartha Sharma, invested to the tune of, as per the.
You are appearing for that Miglani thing. Oh no. What is that?
One is Siddhartha Mano, who is the prime accused, who misappropriated money of the late single leader, and he has invested in a bottling place which is owned by him.
Oh, owned by you.
My bad. Well, now what
They
we
are in
have.
partnership.
No.
Now, whether it can be segregated or not, because proceeds of crimes are there according to.
Now, they are not going to anywhere hamper with the investigation.
So
It is.
investigation is.
Oh, sorry, trial, Miller. I'm sorry, Miller. So far as trial is concerned, Miller. The question regarding whether attachment can be ordered can be part of.
Pass is a legal order or not, that he has to show.
That I have to show, Miller, that whether it is a legal or not. So far I am concerned, I am neither an accused. In fact, I am the witness, Miller. And I have been called as a witness, as cited as a.
And Mr. You have filed it for what?
But my properties has been attacked. I have challenged that
You have appealed for
attachment.
Siddharth.
Yes, my lord. I am appealing for the petitioner in item 11 and 30.
He is the prime accused. He misappropriated money from the.
That is Siddhartha Sharma.
Siddhartha Sharma's
Yes,
house
yes,
and
my
others.
Siddhartha Sharma, Mr. Miglani is
Yes,
appearing.
Yes, my lord. So I am appealing for Siddhartha Sharma.
Okay. So he's also seeking for like detachment.
Setting aside the.
Setting aside of the impugn order, my lord. For
His
attachment.
perspective is different and his perspective is.
My perspective is totally different, Miller.
Then we will fix it some other date. When?
What?
When can it be fixed?
Any date, my lord.
Any date.
Next day, next week thereafter.
Then you write in this item number 11, you write heard Mr. Miglani, Mr. Mohit Miglani, the learned counsel appearing for the petitioner. Also heard Mr. Jet Kamar, assistant learned senior counsel, learned special public prosecutor, assisted by Mr. P. Datta, the learned counsel for the state. For the state, Mr. Miglani, Mr. Kamar submits that he has filed an objection in the instant matter, but which is not.
File and copy served.
Filed and copy served to the clerk of the learned counsel appearing for the petition.
In his order.
But I have to confirm from my clerk also whether he has received any copy or not.
No, without serving it, it cannot be filed.
My lords, I'll have to take the clarity, my lords. I'll take within 2 minutes, my lords. I'll call him right now and I'll take him 2.
Yeah?
Because his is the different.
His is different. Whatever he is stating, I'm just writing it down. Okay, I'm just dictating that. However, the same is. Recorded objection from the recorded that is not on record, right, Tillo? The one that you have filed is not on record.
No, we have filed.
The same is not on record. Mr. Miglani submits that he has not received the copy copy of the objection is it?
Well, our submission.
Be that is it,
That it was served upon this.
no, that I have written that,
Council is
be
not-
that as it
So we
may,
did to
be
his
that as it
reply.
may, let the matter be listed on when?
My lord, on the 28th of August. Madam.
Let the matter be listed on 28th of August, 28th of
Madam,
August.
I believe there is a holiday of Raksha Bandhan on 28th August. Madam.
Then first week of September sometime.
Yeah, 18 August is clear, sir. Yeah, so far we are concerned, we are not close.
3rd September. No, they are closed.
Okay, 3rd September.
Matter has to be taken up together.
On 3rd September.
3rd September.
But can it be possible for second September?
3rd September is fine. Madam.
Sir, say second if possible, sir. I have few others matter in Delhi also. 2nd September if it is convenient.
2nd September.
Second, sir, because my junior also be not available on 3rd. Second,
Will be okay.
second, Milord, second.
Second, Mr. Kamo. No, he is having some problem in 3rd.
Oh, then let us come to my lord 7 or 8, my lord.
7 or 8 is 7 or 8 is fine, madam. So I have no difficulty.
Mr. Bora, 7.
I don't have any problem, Milord, whether it is 7 or 8, Milord.
8 is the hearing day.
He is
8, we are fixing on 8 September. 8 September. 8
Mr. Kamar
September.
has very busy schedules, Milord. I have to ask the dates for Mr. Kamar. So far we are concerned, Milord, they are free, any day.
Have you seen his diary? He's
Yeah,
writing there.
that's why I have told, sir. My lord, that's why I have told.
Yeah.
So far I am concerned, Milord, nothing.
He doesn't keep diary because the diary is always a full. So he extra seats he needs to keep.
That's what I have said, that he doesn't carry diary, which diary has already full.
That's what I'm saying. That's why he
And
keep extra
He's
copies.
just carrying a seat only.
He
Madam,
puts some. He puts some.
My lords, may I make
additional seats. So we are
Madam,
fixing it on 8.
8.
Okay.
my lords, before that, madam, may I make 2 requests, my lords, 2 requests from this court, my lord.
Hmm.
My lords, if the prosecution respondent may also send a soft copy through email. And my lord, second is the respondent has moved an application before the trial court for enforcement of the impugn order, my lords. For direction to the authorities for the attachment, my lords. Today I have received the copy, my lords.
You know,
If that
okay, I see Mr. Miglani, he's saying, Mr. Kamar is,
Let him give the email address.
Mr. Kamar is saying he pass over the email address, he will email it to you. Okay.
My lords, yes, my lords.
He will
And second,
Second one, like, we'll
request-
consider, the second one, I mean, we'll consider on the same day. We'll
My lords,
consider on the same-
my lords, the thing is the application which has been filed by the respondent for enforcement of the impugn order, direction to the authorities for the attachment.
Was
It
there
has
any
been-
other application filed by you?
Yes, my lords. It has been filed before trial court, my lords. It may be kept for the next day, but it has been registered tomorrow. Today I have received the application. If
It has been listed tomorrow. Tomorrow, then we
Yes,
cannot pass any order today.
my lords, what I am submitting,
It's in the trial court.
it's in the trial court, my lords. It's in the trial court. If this application may be kept pending till the 8th.
Mr. Boras got no rule. It is regarding the freezing of the bank account of the primary seekers.
Before the trial court.
So trial court has passed the order,
Ah.
he has challenged it
Ah.
in item number, criminal revision number 350.
So
That is item number 5, the serial number.
Item 11 and item 13, my lords. My simple request is if that application may be kept pending, which has been moved before the trial court. Otherwise, my lords, my revision will become it will affect on my revision.
he's saying some application you have filed there in the trial court, and whether that can be kept pending till the matter is heard.
That is, we have asked for the copy so that we can take action against the order pass, by the order pass, sorry,
Hmm.
for compliance.
That you'll have to, that let it be there. I mean, we are not going into those
My lords,
issues.
my lords, my simple
Now, we are not
request
going
is-
into that issues, Mr. Miglani.
My lords,
If there is something there is something there, you please plead before that court. Okay.
My lords,
I mean, with
said-
your matter is fixed on 8th we have fixed, right? 8th of
My lords,
September.
my
And by that time, you will receive the copy and be ready for the argument.
Yes.
Then other matter, we heard Mr. P. Bora, the Learned Senior Counsel, assisted by Mr. So-and-so. Also heard Mr. Jet Kamar, the Learned Special Public Prosecutor, appearing for the state, assisted by Mr. P. Datta, the Learned Counsel. Mr. Kamar submits that that state has filed an objection in the instant matter, which is not on record. Full stop. Therefore, in view of the aforesaid, let the matter be listed on 8th of August along with the other matter. Along with the other case number.
8th of
Sorry,
September.
September on along with
Criminal revision petition number 317.
317.
And the third one.
317. Okay, then along with 317,
Mr. Boda is
Boda.
connected here. Now we are coming to item number 13 minor, that is criminal revision 318. It is only Siddharth, which Mr. Meglani is very.
So what is happening here?
We are same thing also minor. Attachment order has been passed in favor of the prosecution minor. And the bank account has been frozen.
Frozen,
So he has come up for vacating that.
Okay, so this is also fixed, will be fixed, same date.
Yes.
Okay.
But
In this, here there is no, objection or whatever. We have already filed it.
But same, I have not received the copy of this also.
You kindly pass the
Email ID you sent it.
Malats, I'll do that, Malats.
You
I'll
see
definitely do that.
Then we heard Mr. Miglani, the learned counsel appearing for the petitioner. Also heard
his clerk also.
heard Mr. Jet Kamal, senior special public prosecutor assisted by so and so. Mr. Kamar submits that an objection has been filed, but which is not on record. Mr. Kamar, Mr. Kamar submits that a soft copy you sent, a soft copy of the same of the objection shall be sent to the learned counsel appearing for the petitioner. Mr. Miglani is Mr. Miglani to provide the email address to the learned counsel.
I'll do the needful. Malats, but
listed along with the other two matters on 8th.
If I may sincerely submit, Malats, if those applications which have been moved in trial may kept pending till the 8th September, Malats. If
Let you pray before there, Abhinav, we don't want to enter into that. How can I pass any order without seeing any application, without having anything?
Because, Malats, these applications are rising from the impugn order, which is already subject before this court.
Without seeing that application, what order I can pass from here? I can't do anything. You approach there.
Absolutely.
So,
What is the date fixed for hearing and objection?
you do that. We can't do anything.
I'll do that. I'll do.